All right. What is up, Perps? So we're going to listen to the Maryland shall issue case that happened today in the Fourth Circuit. Um, we're gonna see how this shit show went because this is the same en banc panel that heard the Maryland assault weapons ban and the high cap mag bans. What yesterday? Same en banc panel, from what I can see. 15 judges. Um, Maybe two of them actually care about constitutional rights. So that's what we're going to listen to. I was kind of dragging my feet. Matter of fact, let me post. Let me post Paul from Legally Armed America's video that I was trying to finish up listening to when I started the stream. So let me post that in chat. And this is about this case where the ATF raided this guy's house in Arkansas, what, yesterday, day before, maybe yesterday, 6 o'clock in the morning raid. We heard the guy got shot twice. This dude does not seem like some ultra criminal. Well, apparently, he took one to the head. More than likely 556 or 223. Anyways, on life support. But from what Paul's saying in this video, somehow the ATF is trying to block this guy's family from sharing his organs. I can't even really say just how sick that is. Tread, what's up, my brother? Well, be careful driving, man. And if you're going to listen to this, it's no excuse to run off the road or throw middle fingers at other drivers or honk really loud. So let's see. I'm getting everything set. And this isn't real long, I don't think. I didn't get a chance to listen to it today. I didn't realize it was going on today. I just got up this morning, went to check, and by the time I got up and got my computer started and actually started looking to see what was going on today, it was already 20-something minutes in. So I didn't listen to it and kind of had to dig to find it again and figured we'd listen to it tonight because it's oral arguments. Oh, dude, I need another hobby. Anyway, we're going to listen to this. So you perps, pull up a chair, pull up a beer, crack something, roll a joint, do whatever you got to do to make this a little bit more comfortable. And we're going to listen to this. And again, this is the same, this happened today, but this is the same en banc panel that heard the assault weapons ban magazine stuff in the Fourth Circuit from Maryland yesterday. So buckle up, Buttercup, because this one, if it's as painful as it was yesterday, we all need a damn shrink. What's up, AR? I was just listening to you, brother. Let's see. Let's speed this up where we can get these guys.
Bruin and Heller. It seems to me
this is not about whether Maryland's regime for requiring permits to carry firearms outside the home is constitutional.
You talked about the question whether Maryland can prohibit somebody who's unlawful or not of age.
Make sure everybody can hear the audio because here it is. AR, dude, anytime I can show up to your screens, brother, I love it.
Particular question about
Chambered, what's going on, brother, man? Run guns. What's happening, my brother?
As I read.
No, was serious, though. Anytime you want to come on a screen to hang out,
saying, and I'm asking you whether you agree with this.
Then on some political stuff, you are more than welcome, man. Anytime.
The right of the people refers to the right of law-abiding adult, ordinary law-abiding adult citizens.
So, and I'm going to back that up just a second so I can kind of catch the start of it because, like I said, I haven't listened to this yet. So, understanding of the case. So, of course, Bruin comes down. All of these Democrat cities freak out because, oh, no, they have to be shall issues now. They can't be may issues, don't have to show good cause and all this other horse shit. So Maryland kind of set up their system where they could still drag their feet, still deprive people of their rights, and this is being challenged. And this is running back through the en banc court. So this is 15 judges hearing this. And oh God, man, it's like the assault weapons ban stuff we listened to yesterday. These judges will use any kind of logic they can possibly use to basically uphold the state's power because they believe in the state. They don't believe in the power of the individual. Most all of us, we believe in the power of the individual versus the power of the state. So this kind of ruffles our feathers a little bit. Bob, what's up, brother? I just caught the end of Legally Arms stuff, and I was going back and listening to it while I started this up. Dang old Matt, what's up? Yes, it is time for stupidity. Yep, that's it. Warsaw, what's happening, my brother? Am I dive bombing this one? And who knows? No, this is Maryland's shall issue. This isn't even the AR ban from yesterday. This was from today. So this is the Kerry case on whether or not or how they go about actually allowing people to carry their firearms, their permitting process, how long they can drag it on for, all that. So, yeah, this is kind of like dealing with the way New York threw in a bunch of their shit after Bruin came down, where they just, we're now an issue state, but we're going to put all these hurdles in the way. We're going to, all this is going to go to court. We're going to drag our feet. The court's going to support us and screw the people who want to defend themselves. This is basically where this lands. Oh, yeah. Warsaw, dude, you ain't lying.
Question whether Maryland can prohibit somebody who's unlawful or not of age. That statement raises for me a particular question about this case, which may be somewhat fundamental. As I read Bruin and Heller, it seems to me what the court is saying, and I'm asking you whether you agree with this, seems to me the court is saying that the right
qualitative measures, yes,
refers to the right of law-abiding adult, ordinary law-abiding adult citizens. Is that how you understand it?
I understand law-abiding, responsible citizens are within the people.
Yeah.
The scope of who are within the people is not at issue in this case.
No, I didn't ask you that. I asked you whether that is where the court is finding its construction of the people, isn't it?
The court has yet to focus that precisely on it, Your Honor. And I believe that the Rahimi case might shed some light on that particular issue, but that's not at issue in this case.
Well, you'll have to bear with me because
happy to, Your Honor.
It may be.
Please be patient.
It may be issue in this case. Let's assume, and there may be a debate on
Gabriel,
this.
What's up, my brother?
That the Supreme Court has understood the people in the Second Amendment to mean law-abiding, responsible law-abiding citizens.
Yeah, Matt, that'd be my response to a lot of this.
If that is so, then it seems to me a person seeking to purchase a gun has the burden to show that he's an adult, that he's law-abiding, and that he's therefore entitled to purchase a gun and satisfy those. Now, that makes a lot of difference because now it's not the state imposing it. The burden, and when it comes to the Second Amendment, is pushed on to the plaintiff seeking the gun.
Yeah, Warsaw,
so in this case, that might be relevant because all four qualifications for the license could fall under law-abiding.
We talked to Todd before.
Like you take the 21-year-old age, you take the residents of Maryland, you take law-abiding, and you take the gun safety, which is you have to be responsible. All of those could be burdens that the purchaser has to carry when he wants to buy
the lights.
a gun.
I got the mood lighting.
And so it might be relevant if that's where it's located in the analysis. If that's so, then it seems to me Maryland is on very solid ground. It's carrying out the burden, it's insisting on it, but analytically, it falls on the purchaser, doesn't it?
I completely disagree with you, Your
Okay,
Honor.
fair enough.
And it's
That's
not
why I raised the
relevant.
question.
And let me explain to you why it's not relevant to the court's decision in this case. We're not here challenging background checks. We're not here challenging the ability of the state to determine whether the purchaser of a handgun is a prohibited person.
Actually,
Because we're not
you-
challenging Maryland 77R.
But
Kind
Mr.
of
Rex, can you
related.
say why not? Like, I don't, what is your theory for why the background checks
Hey, green light will work.
permissible? Those obviously build some delay into the time that you can acquire a gun, but this one is unconstitutional. I don't
So-
quite understand.
There's a lot of weight in that word "some" before delay, Your Honor. A
So
delay
it's
of
about the length
weeks,
of the
a
delay.
delay of weeks is unconstitutionally
How long of a
burdensome.
delay is constitutional?
Well, what
Yeah, I think
what
green
delay is necessary? We have an instant check process in Maryland by which all rifles and shotguns are acquired while the purchaser is at the FFL shop. That is an instant check. It happens. In today's world of databases, there is no reason a background check cannot happen at once. So
it's not
if the question is
instant-
waiting, which is not the same as
Excuse me, so
background
if
check.
it's
Oh, not the flashing.
instant, It's
Quit flashing.
not constitutional
There we go.
that was Judge Harris's question. How long is the delay? How long is a sufficient delay in your view? No delay, it sounds
So
like.
we are not here challenging 77R,
Right,
which has a
but under
7-day
your-
delay.
Screw it.
Excuse me, Mr. Sweeney, under your analysis, though, the 77R requirements necessarily fail, don't they? Because there's a 7-day period.
There is a
for which
7-day
the
Flash,
period,
red and
but
blue.
we're not here
I think
challenging
I've got
that.
that on here
No,
somewhere.
but I'm saying your analysis talks about delay and that if a
That's not
person
bad.
cannot instantly acquire the handgun, then their rights have been infringed. Isn't that correct under your analysis?
That's
So
correct, but
so
we are not challenging
necessarily-
77R.
So
77R is in place and HQL adds nothing to it.
So is your
No,
position
but
is that,
that's not the question. The question, Mr. Sweeney, is, under your analysis, 77R is.
Oh, that's a
also
stroke.
unconstitutional, is it not?
77R's waiting period might have to be shortened to what is
That must mess with
necessary.
my eyes.
But you said
Go
what is
back to a
necessary.
solid green call today.
I'm saying that it can be done and is done with respect to long gun background checks instantaneously.
So Sweeney, can I ask you a different question about time? Because I was thinking, the only analogy I've been able to think of is the takings clause, where we say, like, the inability to use your property for any length of time does not become a per se taking. That we don't think about other constitutional rights that way. So can I give you this hypo about time?
If you
So imagine the government
stop
had a
me from
law that
speaking
said
at certain times,
no
yes,
gun
that's a take.
sales after 9 p.m. And one can imagine lots of public health reasons why one might want to say no gun sales after 9 p.m. Now, if a person wants to buy a gun, and then the gun stores can't open until 9.
Wait, hold on, wait a second. So he's trying to get into like time and place restrictions. Time and place restrictions work on speech some of the time. In other words, I can't pull up a podium in the middle of the interstate and start preaching a sermon. Time and place restriction. When does it matter when a firearm is sold as long as it is a transfer in between two people consenting to a transfer and then that gun is not used in a fashion to wrongfully deprive someone else of life, liberty, or property? Back in the day, I bought guns at Walmart at like 12 o'clock at fucking night. Why? Because I wanted to. So this time and place restriction on the purchasing of firearms that this guy's getting into is absolute horseshit. Yeah, they are, man. It's just, dude. There was a time where I grew up mainly on military bases, so it wasn't where I was at. But I'd go visit family in Arkansas, Louisiana, a couple other places around the country, and it was commonplace to have gun racks in the back of trucks where there was at least a shotgun and a rifle hanging in the back of every damn truck. No problems. And I guarantee you a lot of those people were carrying handguns. No problems. Blue laws for firearms. That's basically, yeah. You can't sell a gun on Sunday. What? Pretty sure Jesus would be a fan. Just saying.
9 a.m. So that means a person who wants to buy a gun at 9:01 p.m. has to wait, 11 hours and 59 minutes. Do you think that's unconstitutional? Does that trigger heightened scrutiny
Yes.
under the Second Amendment? No
That is
gun sales after.
unconstitutional.
I don't know.
Doesn't seem kind of important to know the answer to that, because the whole theory you've got here is making me wait triggers heightened scrutiny under the Second Amendment. And saying that I can't buy a gun after 9 p.m. makes me wait 11 hours and 59 minutes.
So what we're losing sight of here is.
Could
this
I be
case is
killed
about
during that
waiting
11 hours and
weeks.
59
This
minutes?
case is not
Yes.
about waiting
Unconstitutional.
11 hours. It's not about waiting 7
Mr.
days.
Sweeney-
Well, then it's
waiting
not,
weeks.
sir, then it's not a claim that there's an infringement under the Second Amendment. It's a burdening
Oh,
of the
man.
right. And the Supreme Court has indicated that you have a right to
Yeah, dude,
challenge
I
the
bought-
burden, either if the time is too extensive.
Hell, I bought
Or
my
the fees
30
are
odd
exorbitant.
that I've got right now
And
at
those,
Walmart at like 10
and so
o'clock at
apparently
night.
what the argument you're making, if I understand correctly,
In
is the time is too extensive.
That's
But-
one of the arguments
But
we're
it
making,
seems to
yes.
me the court has allowed for the notion that some time delay to assure that the person is can lawfully possess a gun, is of age, is responsible, that there is some time inherent in determining that. And so
15,
we're
I
getting
thought
to a
it
point
was
where
16, but I thought it
you're
was
asking us to draw a line as to what
15, my
is
sister.
too long a
Pretty
delay and what isn't under the Constitution, as opposed to the absolute just denial of the right to have a
The
gun.
line I'm asking you to draw here
Big
is
Ty,
a
what's up,
line
brother?
that extends weeks
Private
before
German checking
the
in. What's
7
that?
days required
I
by the
understand. See,
77R.
you're making time arguments, but the question here is this is a shall issue. The gun has to be issued. You're going to get the gun. You don't have to have the showing about whether you have a special showing for your own defense. That's been thrown out. The burden
Yeah, and that
on the right, of too much.
which this judge is about to hit something that's probably going to set me off too. But yeah, back in the day, it was Saturday night specials. We had to have these laws. Saturday night specials. These cheap guns are used in all these crimes. Well, they're used by a lot of people who couldn't afford a more expensive gun, and they're used mainly for self-defense. Yes, they are used by criminals. There's no lie about that. But so are cars and shoes and pants, depending on whether they're on PCP. I realize there are caveats. So are knives and baseball bats and all these other things. The arguments over like the Brady bill, and even background checks in the first place, were these are going to be pretty much instantaneous background checks. Yeah, I think originally there's a 3-day waiting period, which is where we come through a whole nother end of things. But it's not going to be that burdensome on your rights. So these aren't going to be that bad. And a lot of people back in the day went, okay, man, we can deal with this. That's not horrible. But it's just one level, and they keep stacking onto it. And Maryland and a lot of other places, we have instant background checks. If you can't run a background check on someone instantaneously, it's because the government is fucking up and not doing their job. So if the government's not doing their job, why am I deprived of my rights? Because the government can't do their job. I used to think about background checks. No, not too bad, whatever. Never really paid attention to them. Passed all the ones I've done until the last one. And then I got held up for, what was it? I got denied, then I got delayed, then I got pending. And that went on for almost a month before I finally just went and picked my gun up because it was legal for me to do at the time. And then weeks later, the FFL that did the transfer talks to the ATF, and they're like, yeah, everything's fine, no big one. No, we don't know why that happened. It's the inept government. And they did. This shit is on purpose. This isn't an accident. Yes, AR, that is 100% right. How do you think the ATF has the data they have now? It's from NICS checks. The ATF already has an illegal gun registry from NICS checks, which people, when you go back and look at arguments, people warned about that then. Something from an FFL. Yeah, 2 more days. Yes. Delay every other 4473. This last one is the only time, even a month after I got my rights back, got all my stuff squared away, I passed a background check in 5 minutes, buying 2 guns. I bought my 1911 and I bought my wife a double barrel. Well, actually, she was paying for it because that was kind of the treat. But the background check was underneath me. The 1911, the Fox double barrel 12 gauge, no problems, straight through. When I bought my Remington 30-06 at Walmart, like 12 o'clock at night, 10 o'clock at night, whenever it was late. No problems, went straight through, not an issue. This last one I did, the last transfer I did was for that frame or for that receiver for my SDI classes. That went on forever. Like I said, almost a month before I finally went and just picked it up. It's freaking ridiculous. And when you look at the statistics on how many background checks are denied versus how many people are actually criminals buying background or buying guns that get denied, something like 97 to 98% of FFL or the NICS denials are false positives. The system's broke, but that is a feature for the government, not a flaw. So when it comes to Maryland shall issue, those background checks take no time to run. But they want to figure out ways to hold people up.
Much time or too exorbitant a fee has been recognized. So the question is, it sounds to me like your case is coming down to the one issue: is the time necessary to carry out
Yeah,
the
Bob, I can
Maryland
see that happening.
statute too long?
No, you're wrong, and let me explain why, with all respect.
Well, your whole argument is time
That
anchored.
is not my whole argument, Your Honor. And this is not a shell issue regime. You cannot obtain a handgun when you get an HQL. I can't get it. I have my HQL, I go down to my
Brother Ray,
FFL,
take him
and
easy,
he
man.
goes, not good enough. Here's the 77R.
So let me ask you this, Mr. Smith. I'm over here. You said you're not challenging 77R. So is it
Correct.
your position that
No.
77R is constitutional?
That is not my position.
You're just not challenging.
Correct.
Okay,
Okay.
let's put it this way. Explain to me how it's possible to write an opinion
I can get my
that says this is invalid,
to work.
77R is.
Let me tell you exactly how you can do that. You have a sufficient process for prohibiting
Hey, Art,
dangerous
you're still in,
individuals
man.
from
Drop
obtaining
your,
handguns in 77R that's in
channel.
place and not challenged here.
It's
You
not
have-
challenged because of the technicality that you don't challenge it. Okay, so
If-
here's,
if-
here,
if I
know
may
you don't
finish
think-
your-
no,
my
let
response.
me give you this hypo. Imagine that you challenge 77R. Imagine, so you cannot say, we're not challenging 77R. How does someone write an opinion that says this law is invalid, but uphold 77R? I know you don't think that's actually true, but how does one write an opinion that says that?
Because the HQL is a redundant layer extending weeks before you can even apply under 77R and is not sufficient to get you a handgun when you're done with that process. That's why I can say that.
But then why isn't Judge Niemeyer right? That the challenge you're really making is an excessive burden challenge that the Supreme Court says is made one particular way, not the way you're trying to make it.
Well, first of all, I disagree that this is
Oh,
not the
okay.
way to make that challenge. I'm making that challenge, and I'm here today to make
There are
it.
no background
And that challenge
Richard,
is sanctified.
Counsel, it's not the absolute
Freedom
length of the
period for
delay.
Rich.
Is it as much as it is the reasons for any delay and an arbitrary length of 6 6 days, or it's hard for me to understand what time period is presumptively lawful or presumptively unlawful until I look at the reasons for the time delay. And here the reasons are,
You want to know what's presumptively unlawful, Judge? Any delay, period. Any, at all. Any delay. The state constitution of Maryland, it's been a while since I've read it, doesn't give the government any power to regulate arms. Therefore, any law based on the Maryland state constitution that actually regulates arms or the carrying of arms is, guess what? Unconstitutional. You douchebag. Bob, yes. He'll be like freaking what was her name on the Supreme Court? I can't believe I can't think of her name. I can see her face bigger than shit with her little doily lace freaking collar. But yeah, it should be like her. He'll go on forever. So Jim Henson Muppet creation. Ginsburg, yes. Can't believe I could not. Well, trauma is a thing, kids. Just to let you know.
are twofold. One, a background check, and two, some minimal training. Now, aren't these fairly standard kind of reasons? Is nothing that, and if they're abused, that's something else. But given that this is a facial attack, what is wrong with the need to conduct a background check or the need?
Tread, if you are reading that and if you have not completely snapped out, you are a saint, or you're smoking a gloat of weed. One of the two. Are you suffering cravings for Cheetos right about now? Are your fingers orange? Are your fingertips black? Because that's the only excuse I have for not snapping out reading that.
Need to have some minimal training.
So minimum training existed under 77R prior to the HQL, certainly can be done within that waiting period as the state used to do it. As a matter of fact, it could be done in the FFL's office at the time of initial purchase.
But you're
So
getting
that initial training can be done.
You're getting very close to saying that
Fun, what's up, my brother?
any delay resulting from a need to
Cheetos.
conduct a background check or the need to have some minimal training is just presumptively
well.
unconstitutional.
You got me there,
I mean,
Chess.
that's what you want us to rule.
And that could lead to
That's
a
not
whole
what
lot
I'm
of
asking you
jokes.
to rule, although you're trying to get me to say that. No, Your Honor, that's not what I'm asking. What I'm saying is the difference between 6 days and 6 weeks is constitutionally meaningful. That's what I'm
Well,
saying.
that comes down to simply a time
Vanessa,
argument,
what's
and
up?
I'm happy to have that be the argument. But it seems to me if that's so, then we ought to engage on the discussion as to what is burdensome in violation of the Second Amendment and what is justified.
But let me reiterate, I'm making a twofold argument because the 6-week delay does not result in a handgun. You can't get the handgun with the HQL. You get the handgun with the 77R. That's how you get a handgun in Maryland. That's the process that Maryland relies upon.
You don't realize your argument still is a time delay argument. The whole business is background checks and the course,
Right.
the training course.
Is a
Those are
right
the two
to
things
not.
that are being done.
If we
And
were
the
here,
question is, if that could be done in one 24-hour period, we wouldn't be here under your argument. If that takes 6 weeks, we are here.
Correct.
So that's the argument you're making. And so
But the
I
argument
think
I'm making
just
is
a minute,
that-
sir. If that's your argument, then
that's
it
not my
seems-
argument.
You keep making it and then you say it's not your argument.
Because you
retract.
keep
gotta
slicing
prove
my
some
argument in
argument.
half.
All right, tell me what the difference is between a process that takes 24 hours. You have to take a course. You have to have a background check. It's all done in 24 hours. And I don't care whether it's under one process or the other process. You collapsed them all and did it within 24 hours. You just agreed that wouldn't be a problem.
I don't think that would be a problem.
All right, so now we have a process that does the very same thing through two processes that takes, you say, 6 weeks. And there's a problem, right?
I would say so, yes.
Okay, now what's the distinction between the two? Is 24 hours versus 6 weeks?
Because the 24-hour process.
Okay. Judge, let me explain something to you because you're obviously an absolute moron. So when the Second Amendment was written, I might have to take a day or two to get to the person selling the gun. I didn't have Amazon. I didn't have drones that could drop them on my front porch. I might take that long just to travel to the person selling the gun. Okay. That is a constitutional kind of functional delay. That's just time, me getting there. Me not being able to get off to work to make it to a gun store while it's open until the weekend. And I have to spend a couple days. Yes, that's a completely constitutional kind of delay on that right. The government putting so many restrictions on me, I can't go in and use the representation of my hard work and my labor to pay for a product and then receive it same day. Excuse me, that is an unconstitutional restriction. Anybody got any Quaaludes to spare? Maybe some Xanax? Joint? It's just fuck me running, man. Judges really and truly should be advocates for the people, being a check on government power. There are documents called constitutions. They look at a constitution, they read the words in that constitution, and then they look at a law and they go, no, government, you can't do that because it doesn't fit into these words that we're all agreed to. Or they go, yes, government, you can do that. It's right here in this wording. You're covered. Okay, the people have to put up with it. That's the way judges should operate. However, these judges have a big rubber stamp attached to their gavel, and all they do is rubber stamp the tyrants who write these dumbass laws. And in my very humble opinion, these judges should be impeached for not upholding their oaths to actually uphold the Constitution, whether it is of the state of Maryland or whether it is the federal Constitution. Either one. Doesn't matter whether you like it. I don't like getting cut off in traffic. It happens, is what it is. I don't like lots of dumb shit that the government does.
Process is sufficient to do what you need to do, and the 6 weeks is a waste of everybody's time and money, and it deters people from exercising their right. And that's why we're here, Your Honor.
Well, I understand, but so it comes down to question, is the time after the 24 hours is burdensome under the Second Amendment, and that's the argument we have to address, and you have to tell us why and where the lines are.
Sure. So let me tell you why. The judge in this case below, Ellen Hallander, addressed this very specifically in her opinion. And Your Honors should be directed to the finding that she made with respect to burden. And she found that it undoubtedly burdens the core right. It's Ellen Hallander. Because it makes considerably more difficult for a person lawfully to acquire and keep a firearm for the purpose of self-defense in the home.
Mr.
The
Sweeney,
district court's holding is surely right.
Mr. Sweeney, we're talking about an entirely different analysis now. Judge Hollander didn't have the benefit of Bruin, didn't have the benefit of the court's discussion of shall issue regimes and exorbitant fees and lengthy wait times. None of that was before her. And I think that it would be.
So wait a second. She said it was unconstitutional before all that.
The issue of lengthy wait times and exorbitant fees. It sounds to me like you're saying anything more than a day is presumptively unconstitutional. Is that correct?
First, let me address what you said about Judge Hollander.
His children.
Respectfully, She was addressing step
I can't
one.
say you're wrong,
She
team.
was addressing whether
At
or
all.
not the text, under the text of the Second Amendment, the conduct and question
Right. But
is
in-
impacted.
in
That
addressing-
step is
okay,
still
please-
part of Bruin.
Please don't shout over. In addressing.
Well, bitch, quit talking over him.
You are also addressing step one when you were talking about a temporal delay, are you not?
No,
Why not?
that's a step two
I guess
analysis.
that's the reason it's a good thing I'm not a lawyer.
Because the burden of preventing someone from acquiring a handgun instantly is enough to get to step two.
So you're assuming a burden, are you not?
No, I'm relying
No,
on the
it's the
district court's
state's burden.
holding that there was a burden.
Is it,
Undoubtedly burdens the core right to acquire a handgun.
is a background check a step one or two? Just a pure background check, nothing else, whether somebody has a criminal record. Is that a step one or step
A
two?
burden.
Step two.
Well, where do you, why do you
Call it step
discard
one.
the step one definition of people that the Supreme Court's adopted, that the people means unlawful citizens?
I don't.
Well, if that's a step one, then the purchaser has to demonstrate that he's a lawful citizen. Adult lawful citizen.
No, that's not the way that works.
I don't know that as a prerequisite to the exercise of the Second Amendment right to defend yourself.
I'm going to stop his argument right there. That's not the way 4473s and background checks work. 4473, a background check. It's basically me having to jump through a government hoop and try to prove that I am not a criminal before I purchase the product. It's not about the product. I'd have to distill that argument a little bit more. But regardless of any of that, what should matter is what I do with the product, not just merely me having the product. Doesn't matter whether it's car, gun, knife, I don't know, grenade, doesn't matter. What should matter are my actions with it. This entire background check system is absolute horseshit. So it's just become another, if the government doesn't do their job or they do their job really poorly, which typically government does, they get to delay your rights even further. And that's an absolute feature. It's not a bug. It is on purpose.
I have to demonstrate that I'm a law-abiding citizen.
The right
If
is
I
granted
defend
to the
myself in
people.
my home, I don't have to do that.
You do have to
Maryland-
be a people. You have to be within the definition of people.
But do I have to
Oh, yeah, I saw that. Matt.
prove that before I get to exercise my right to self-defense? I submit no. I'm in my home. I have a firearm. I defend myself. I don't have to prove that I'm a people first. Now, in order to do that, I have to acquire that handgun. Do I have to prove I'm a people first? You burden that right. Now, I'm not saying you don't have a second step
Let me
analysis.
just ask a question about this. It seems to me that you want to now rewrite Heller and Bruin because as I understand the test, the purchaser has to exercise the right and satisfy the requirements of the plain text. Once the purchaser satisfies he comes within the plain text of the Second Amendment, the burden shifts to the state to show a limitation or a regulation that's justified by historical experience, whatever. In this case, the court clearly put into the first a definition of people, which it understood people to mean. And as I understand it, I may be wrong on this, but as I understand the two opinions, that
You're
people
wrong on it a lot
refers
of
to
times.
adult, lawful citizens, responsible citizens. And if I'm wrong on that, if it does refer to that, it seems to me that somebody who wants to exercise the right has to be a person who's entitled to exercise the right.
Okay. Look here, Judge. plenty of people, most law-abiding people, mostly law-abiding people in the United States, will commit crimes during their daily life. There are so many criminal laws, we just don't know them, and we will commit a crime. And if you've never read the book for 3 Felonies a Day, or like me, if you don't have time to read, if you listen to it on Audible, it's there. Very good to listen to. And I will submit, I could be a drug dealing, absolute law breaking piece of shit, and I still have a right to self defense. If I am not breaking a law at the time, I am doing my own thing, and then people break into my home to harm me, I still have a right to self defense. If I am in prison for a crime that sent me to prison, even in prison, if I'm attacked, I still have a right to self-defense. It's also why I go to, if I am out on the street walking around free, I have a right to self-defense with whatever tools I see fit, and firearms being the best tool, I have the right to those. So these judges will go through whatever mental gymnastics they have to go through to uphold state power. They don't give a shit about individual rights, individual freedoms, none of that. It is all about the power of the state for these guys, and they should be impeached immediately whenever they do anything outside of the constitutional restraints on government. However, that's not the world we live in. In all these cases, this one I'm sure, they talked about it yesterday, this one I'm sure they'll want to kick back down to the lower court to have the lower court run through their little circle jerk for a while, because what they really want to see is they want to see the Supreme Court flip back to a very leftist bent, and then these cases will go to the Supreme Court, and then all those rights are gone because, hey, the Supreme Court said it. A Supreme Court that upheld slavery. Yep. This whole thing is insanity to me.
And he has to demonstrate that before he can get the right. And you're saying the right of self-defense, which is also inherent in it, it's the right to keep and bear arms. It doesn't say anything about self-defense.
Yeah, you're right about that.
But the pre-existing right, which was for a lawful purpose. But it seems to me that falls on the purchaser of the gun. And you seem to suggest the state has to demonstrate that. It seems to me the state can enforce that. But it could basically say to the man, give me an affidavit.
I will come get one.
That satisfies that you're
I'm listening. I'll be back.
You and I may disagree on
Here-
what exactly this.
Well, I'm going to mute my mic so you won't
No,
hear
I'm
me.
trying to read Bruin.
Under Bruin and Heller. But I don't think it's necessary for this case because we're not challenging 77R.
It's not a question of challenge. It's a question of what if I'm right about this, if this is part of step one, then all the requirements that the state imposes during that 30-day period seem to be focused on the definition of whether the person is entitled to have a gun.
Well, I disagree with that.
I know you've disagreed with everything. You make an argument and then you say, I disagree with it. The argument is, I thought you suggested that was a definition the Supreme Court gave of people, but maybe it's not.
Your Honor, I already addressed that.
Well, could you answer it again, please? Because I don't remember.
I don't read the people as being quite that constrained.
What does the Supreme Court say the people are?
They say they're law-abiding and responsible. You're saying that all people, in order to be eligible to exercise.
I didn't say all
Second Amendment
people. I
rights,
said to demonstrate
have
that
to
you have a right. You have to be.
demonstrate that. And I'm disagreeing with you.
Thank you, Mr. Sweeney.
Thank you. I see my time is up.
Mr. Dietrich?
Good morning, Your Honors. May it please the court. Because the state may set substantive requirements for handgun ownership, which the Supreme Court in Heller said that it may, the state may use a licensing system to enforce those requirements. And this non-controversial principle, which is applicable across the spectrum of constitutional rights, controls this case. We start with Heller, which stated that the Second Amendment encompasses a right held by law-abiding, responsible citizens.
Does footnote 9 of the Bruin opinion cloak shall issue regimes with some sort of presumption of constitutionality absent a showing of abuse?
Yes, is the answer. I think the challenge here, as we've
I mean, the
seen,
footnote says we're not casting aspersions on a shall issue regime. And then then the footnote goes on to say, but there could be instances of an excessive fee, an excessive delay, an excessive intrusion, all of those kinds of things. But absent some evidence of abuse in the record, the shall issue, as opposed to the may issue regime, enjoys some sort of presumption of constitutionality, does it not?
we would agree. I think the challenge for this court, for the litigants, for
'Cause Green was
everybody waiting for guidance from the
festive.
Supreme Court is to figure out, how do we get there? How did the Supreme Court get to that
Where do
conclusion?
you think that fits? So if we were to read footnote 9, as Judge Wilkinson suggests, where do you think it fits within the Bruin two-step, if you would? Is it in step 1 or step 2?
I think there's two pathways.
I know, I'm asking you which one you you represent the state of Maryland. I'm just asking what the state of Maryland's view is. Is it a step 1 or a step 2 footnote, right? Does it address step 1 and the people, as Judge Niemeyer suggested earlier, or is it step 2? In which case there's a historical analog that we look to.
I don't want to be disappointing, but I don't think it matters. I think that we get there either way.
Okay,
First
do you have a position on which one it is, or you just?
You're
don't
so
wanna answer?
funny.
I am so funny.
I'll answer it. We can go the first step.
Practically a
The
standard
first step
between-
says we look at the text. We look at who are the people. The people are those who are law-abiding, responsible citizens. And therefore, those who are not part of the people don't necessarily have Second Amendment rights.
Well, have
And-
you ever challenged in this case that plants are part of the people?
No.
Yes, man against the masses. It is still technically daylight where I'm at.
For purposes of this case, yes.
What's up, my brother?
These, as far as we know, these people are not.
Is your view that the Second Amendment places a burden on the people?
I grabbed the kid, the phone in the other
prove
side.
that they fall within the polity in order to buy a gun? Is the Second Amendment a burden on people, or is it a limitation on government action in Maryland's view?
The Second Amendment allows the state to enforce substantive limitations on that right.
But it's a
through licensing.
limitation on government action, right? It doesn't place any affirmative obligation on any given person who's not a part of the government to do anything, right?
No,
Say hi to Ting
the
Ting.
Second Amendment, as you know,
Ting Ting.
embodies a
Ting Ting.
right. So it's in that sense a positive right that
saying hi to Ting
that the Constitution
Just to say hi to Ting Ting.
has, but it embodies all of that.
Well, damn,
all
fuck
the
man
meaning
against
of that
message and
text,
chessboard. I ain't gonna say hi to
history
them.
of that text, and the context, and it
Fuck y'all,
allows
I
the
guess.
states to retain that police power.
It's the hose
to
for
enforce
hose for
substantive
poor bros.
limitations that are part, whether they come from the text or they come from the historical tradition, whether the people.
It makes a difference, because the
Yeah.
analogs are more difficult for you in
Yes,
this
100%,
case.
man.
And the suggestion that lawful is a prerequisite to owning a gun.
Not a
If
woman. I don't
11-year-old
understand y'all's
came into
terminology.
the store
I figured out how to do it.
and
Figured it
the
out.
store owner
Figured it
said,
out.
I can't sell you a gun.
And Ting said hello. Miss
And
Ting Ting.
is that a violation of constitutional right? The 11-year-old said, I need it for self-defense.
Well,
It's
it's
the inconsistency
not,
with
and
the
it's
hydrogen.
either, and again, it's the challenge. It's either because that 11-year-old is not part of the
You know
people,
what? This is what men
or
do
that
to
11.
get when
But
they're trying
if
to
you
talk to women.
disavow, if you have for purposes of
Inconsistency
this
with the
case,
shit.
this
So I figured out the hydrogen is my woman.
analysis, the people
I can
question,
feel that.
where are you placing?
In your
This
heart and
is-
soul.
Kind of go on the adversarial system. So where are you saying
I think I need more, Matt.
fits in the Bruin analysis? It sounds like you have said so far it doesn't fall at the people stage. Where does it fall?
No, I'm,
I put film for the,
You could say it falls a bunch of different places.
On the
but
water?
where do you say it
I
falls?
was letting it hydrate.
it
And
can
I was
fall at
holding
the
the
first
stock
step,
up. And I was like, okay, I'm
and
gonna
it fall,
follow it.
or it could fall at the second step.
Practice the
We need that key piece of information of why is the right limited to law-abiding responsible citizens? Is it
Well,
because of
preliminary
textual?
Inquiry to that is, how did you come about the concession? Because, back to Judge Niemeyer.
Whoops.
Question.
I'd have been so fucking mad.
The question was, Maryland has to make that determination initially, not you. And you may make it for purposes of this litigation, but.
That may be one of the reasons I don't have a better camera,
That one
man,
requires
because
Maryland to
you
do
will do better me.
And I assume by doing this, you had the benefit of something, the background check.
Well, I
and
keep
you know
my
they're
lighting all
21
messed
years
up.
old or something that's here. That's a step that you've taken for purposes of the litigation, but in terms of analyzing this statute, how this is applied here, we go back to Judge Niemeyer's point that when we're looking at step one, Maryland has it falls upon the citizen to come and say, I'm a citizen. And to do it, they have.
This judge, if he's the same one I'm thinking about from yesterday, because remember, this is the same en banc panel from yesterday. And let's remember how we got here. The Fourth Circuit thought they were going to lose this case if it went to a 3-judge panel, because that 3-judge panel that they were going to draw was more than likely going to side on the side of the people. This judge, if he's the same one I'm thinking about from yesterday, well, he's special, to say the least. Night Strike, what's up, brother? You know what to do. Yeah, probably. Yeah, let's listen to Captain Special Bus right here. I'm sure his window was really clean.
Have to come forward. So apparently they've done that. But how did you come to the concession? Is it?
Oh, and this is part of the point I was going to get to. So this came down through McDonald, Heller 1, Heller 2, and then to Bruin, to basically a 2-step test, which meant, does this implicate the Second Amendment? And if it does, is there a historical analog to it? And guess what? In any of your permitting laws, yes, it implicates the Second Amendment. And no, there is no fucking historical analog to it. And it should never make it through a state court, much less make it up to a federal court. But here we is. Jesus.
Any different than the way this is done here?
There's been no analysis of these plaintiffs. I think the key part is that it's a facial challenge. And so it doesn't matter whether. I'm sorry?
You conceded it. You conceded that they're legitimate.
No,
They're part of the people. You just stood up there and said it.
Well, if I did, I apologize for that. What we conceded is that it doesn't matter. We can see that there will
Under
be
the
people.
procedure, the gun dealer is the agent of the state. He's the one that has to ascertain that they're 21 years of age and they're don't have a criminal record or whatever.
So I think there is a
That they're
burden.
part of the people, that they're qualified to buy the gun.
There is a burden on the gun seller.
He's an agent of the state.
Night Strike, I will make you
He has
text
to
me all day
comply with the
long.
law. Otherwise, he's probably committing a felony. Or some kind of
Ooh,
a
speaking of that, I still haven't shown my wife the other pictures
Yeah,
of the
but
room.
I want to be clear that there's an independent burden on the gun seller. The gun
What?
seller, there's an independent burden. The gun seller has.
He's acting for the state of Maryland.
But with regard to the handgun qualification license law,
Is
the,
that-
the only burden on the seller is
I didn't know
to,
what I showed you.
do you have a handgun
Oh, I did show
qualification
you.
license? Oh, you do?
I
Okay.
did show you as
Then we
well.
move on to the next step.
Okay.
Show him my, I was trying to find a funny name for the hydrodet, but I can't. Hydrodet.
Law-abiding, responsible citizens. I thought you were-
The devil's wrapping paper.
Devil's wrapping paper. That's my wife's description of
We-
hydro dip.
They have not gone through the
Does it matter if these
Why aren't you doing it? 'Cause I have your phone.
Yes, you have my
Is the point of this statute to make sure
I'm
that
so
whoever
over it.
buys a
I'm
handgun
over it this whole
isn't,
day.
like,
Oh, fuck it,
who
we-
cares if they've identified some specific plaintiffs
can
who are
we go get
law-abiding and
margaritas?
responsible? This law doesn't just apply to
We can
these
go get
plaintiffs, it
margaritas.
applies to everybody who tries to buy
I
a
wouldn't
handgun.
make another beer.
I think that's correct. I think the fact that it's a facial challenge is what's crucial here, not with regard to the particular.
Hold on, Mike.
We're taking what they say in the complaint to be true.
Yeah, yes, thank you for
We aren't
that.
conceding anything's been done.
You know I love you.
Discovery or anything.
Why is that?
That's correct.
Facial challenge.
After the whole
There's
event.
nothing, I think, unique, extraordinary, special
We are
about these,
accepting their complaint.
that they have advanced people, individuals
Incident.
who want to, or I suppose, want to get a handgun, but are unwilling
You know,
to go through
replace
the
the
process.
margaritas.
Let me ask you this. You talk about the process. And,
That ain't gonna happen.
Mr. Sweeney has raised this
Another
point.
place. I think
It seems to me it has some legitimate.
That will
bearing
help you
here.
be single.
The state requires the purchaser to get a license.
Saying, go and make
And
that
that could
U-Haul
take up to 30
reservation.
days. It may take less in a matter of practice, but it could take up to 30 days. And then when he's got the license, the state requires him to get a permit.
But anywho.
And Mr. Sweeney says the requirements for the permit
And I was like,
are
oh, I can go get us
overlapping
margaritas.
with the requirements for a
Oh,
license
tell me that was
and
enough.
increase
I
the
didn't know
time
that.
period
I didn't know-
unnecessarily for, say, another
No.
2.
There's Mike.
So now we have 6
By the way, I'm sporting the It's
built
Kurt's
in with
Fault
this
shirt today.
fairly redundant
Let me
type
get
of
this to where we can see what the hell we're
bureaucracy.
doing.
That's his point, I think.
But you got to do it to where it's
And my question
double
is,
on the
what
side.
is the
Yeah, I know.
justification for
I'm
the state
getting
to have
there.
the requirement for a license and a permit?
Joe Morris, what's up, brother
I
man?
can unpack some of the things
See,
you said. So
I'm
talk about
sporting
a
the Ron
license
Wayne
and a
T-shirt.
permit.
It's Kurt's fault.
The handgun qualification license is the only.
Everything's
permit
Kurt's fault.
Yet.
Yeah.
They apply for that. They have to go through.
And
the
Kurt, if you're out there, I'm
wouldn't
sorry,
They
bring
don't
but
get a gun after that. do
Ron
they?
sent it to
They
me.
do not.
Tacos either.
Okay, well, but I'm trying to get to my point. My point is they have to go through another process.
Correct.
All right, and Mr. Sweeney argues that second
Depends on the quality.
process
Tacos
is
and margaritas,
is redundant in many respects to the first process. And so now that is an aspect of the burdensomeness.
I can eat
of the
chicken
6 weeks.
tacos.
That's,
This
I
is
think
chicken
I'm
taco.
understanding what he's saying on that.
Right, and
Yeah, you are the
I'll
white meat.
get to your point. I just want to push back on
100%.
the 3 weeks because the 30 days is a statutory ceiling for the.
You could be a pork
So
taco.
it's not, and
No,
there's evidence in the
It's the other
record
white
that
meat.
these
Nope.
licenses
Whiter
were
than
being
that.
Let's
churned
not
out.
argue the facts. We have a statute that allows the state up to 30 days to issue the license. It has
I'm
to
not
issue
sure
the
where to go
license
from
within
there.
30 days.
That's
And
correct.
Neither
you
am
have to
I.
have the
I
training.
just
But
wing it.
you have to
That's
get to my point. My point is that there is a secondary
Probably
process
wise.
behind the licensing process.
Yeah.
Which is in aspects redundant to the licensing process. And that, because it's redundant and adds another 2 weeks, he argues is burdensome.
And I think where they complement each other is that when you get the handgun qualification license initially, and then you have a permit whereupon you can go to a gun store thereafter and purchase a handgun.
But isn't what we're,
Oh
what
my
we're
God, the
discussing
Crypt
here
Keeper's back.
more appropriate to an as-applied challenge?
Sounds like
at
he's
a
got
later
strep throat.
date? I mean, what we
This
have
dude has
before
smoked
us
way
is
more than I
essentially
do.
a facial challenge to the law. And that seems to me.
That's how you know you smoked
a
one
very
too many
bold
cigarettes.
move
I smoke
take
a
at the
lot.
outset to strike it down. But later on, some of the questions that we're asking go to how the law is applied. But I see those as questions to be answered further down the road. What's before us now is a facial challenge to the statute. That's different from questions of fees. It's different from questions of time. It's different from questions of
This dude doesn't have
permits versus licenses. Those are all legitimate questions. but I think they're not before us in the here and now. Before us maybe in
Bob
some
said-
future-
You're not wrong, Bob.
some future date.
Somebody
Just
I'm
unplugged
wondering
the
in
judge.
footnote
Do
9,
not
we
resuscitate.
talk a lot about step 1 and
Plug it in
Wow.
the
step 2.
floor, knock the plug out
But
of
I
the
wonder if
wall.
footnote 9 doesn't
I
carry
said the
us a
same
good
thing
way
about Ginsburg.
in suggesting the
Yes.
sequencing of
Problem
proof.
is they kept plugging her back in.
That's just not any old footnote. I mean, footnote
Luckily, the
9
light
is
bulb
a
finally went
big
out.
deal footnote. It's not just any old footnote.
Oh, hold on, I'm getting emails.
And
from-
it had to be carefully negotiated within the court itself.
Hold on, let me text you again.
And
Yes.
the footnote suggests a sequencing here, which is that there's a presumption of constitutionality for shall carry regimes, but that presumption can be overcome with a showing of abuse. And they list 2 or 3 different ways. But that seems to me the subject of a future lawsuit and a future as applied challenge
You
and a
think?
chance to develop the record on how the process works, which we don't entirely know how the process works at this very early stage. What we're asked to do is
You
to
don't
strike the
know.
whole damn
How do
darn
you-
thing
hold on.
down
Because you
at
got the
this
same
early
question I
stage
do.
without proof of
How do we not know how this works already?
I can't tell you.
If you've had your brains knocked out with like a dildo the size of the Titanic, maybe you don't realize how this works. And that is, oh, well, that was so censored from what I was going to say. But anyway, we all know how this is. They put in more and more roadblocks to delay you from being able to do or purchase arms to carry arms for self-defense. And criminals don't give a shit about it. Criminals keep doing their crimes. And it leads to more victims, and they use those victims to push more gun control. That's
Here.
how this has always worked.
Here, buddy.
And chessboard says money. Yeah,
Here.
that's it.
Yeah, that too.
You're welcome.
You could get a concealed carry permit in California or Hawaii or New York very quickly if you had money.
Look at this dumbass cat.
I don't want to look at your dumbass cat. I want to drown him.
its operation. And that seems to me to be a precipitous step to take at the outset of this whole controversy. You see what I'm saying?
Yes, I do, Your Honor. I agree with 99% of what you said. The 1%.
What's the 1%? You don't lie.
Is that the record actually does show how this plays out.
Before you get to that, and
Well, that's a bunch of unprocessed wood, Night Strike. That doesn't count.
That's my backyard
I do have
range.
a question about footnote 9, and he did point out.
That's
that
before I put up the
footnote 9
backstop and
referred to
everything.
Shall,
That's
shall
unprocessed
issue
wood.
carry
It's still
permit.
wood.
This is not
You
a
got to semi-processed
carry permit
wood.
regime, right? This is the.
I can show you the
requirement
flooring
to
I did.
possess a handgun.
If not, I could just send you pictures
Does
of
that matter?
popsicle
Is the
sticks.
test more stringent because?
You have those all over the house because
goes
you have
to the
kids.
Preliminary right of someone to simply possess a handgun?
No, it doesn't. And there's a few reasons why. The first off is that the Supreme Court, when it
I'll be
talked
right
about
back.
the
I'm
right to
lucky.
keep and the right to carry, they were not two separate things. They were on the same level. Secondly, even in one's home, if you were to use a handgun to carry it around your house, you're still bearing it. So that the right to bear is still being implicated by possession in the home. And the right to bear has to be preceded by the right to keep or acquire.
Okay,
And-
so what's the 1% you didn't like about what Judge Wilkinson said?
No, I loved everything. Let me say, but the one point of disagreement is about the record. The record does show that that no license was pending for more than 15 days. So
There we go.
that,
That's it.
that it's not 6 weeks. It's demonstrably not 6 weeks. And what I completely agree with is that anything related to time is only appropriate in an as applied context.
So counsel, can I, maybe some of us do care about step 1 and step 2, even though maybe we shouldn't, but I'm at least curious about Assume there was a Supreme Court decision that said that this type of inquiry necessarily requires a step 2 analysis. So I know you say we might be at step 1 for maybe a couple of reasons, but assume for my hypothetical, that's not possible. You're limited to satisfying Bruin step 2. Explain how you do that.
I think what I'd start with, the premise is that Bruin already did that analysis in footnote 9. Footnote 9 was preceded by the text, history, and tradition standard. So
But if I could just kind of humor, I mean, I think it's a strong argument to say footnote 9 means something, but exactly knowing what it means to me is harder to figure
There.
out. So
More will.
I'm saying footnote 9.
Hold on, I'll show you.
may
Show it
give
again.
us
Hold
a-
on, let me do.
You still got to do the test.
Where's
I don't
the
think anyone would
freaking-
say, I don't need to meet Bruin footnote 9's a whole.
More
thing,
would. Morla, look at
done
that.
with.
That's
And,
a Chinese
That's your
RPK.
position, fine. But I'm trying to get you to give me your best argument as to how this regime.
They wanted to see the wood.
satisfies a
They
step
did.
2
Hey, I'm all about showing your
analog
wood.
analysis.
and I certainly don't, I'm not trying to evade the question. It's a matter of, we know the destination. We're just worried about how to get there. And I understand that that's your job. So to write the opinion in that fashion.
Email it to me.
And I'm giving you 2 pathways. And we don't know because the Supreme Court didn't tell us in footnote 9 how they got there, but they got
Well,
there.
do you have a historical analog that would support licensing?
No,
Not
they
licensing
don't.
itself, but the fact that when you have substantive limitations on the right, which
Well,
Heller
if you have
says
no
there are,
historical analog and you're in step 2, as Judge
Then your
Quattlebaum
whole
would have
case
you
fails.
suppose for the hypothetical, if you're in step 2 and you have no analog, then your position fails, doesn't it?
no, because the analog, the historical tradition
At Gmail.
is the denial of the right or to precluding or prohibiting the possession of firearms by those who are not law-abiding, responsible, dangerous individuals. And so if the
So
state
do you
can
think
do that,
the how analysis for the analog just doesn't matter, right? Because the how, right, the prohibition and after the fact punishment, the analogs that you pointed to, none of them prohibit everyone from having a firearm on the front end. They're not licensing regimes. And Bruin tells us when we look at analogs, if we're in step 2, that we've got to look not just at the why, which is what you want to talk about, but also the how.
I'm going to say this here. So this is 15 judges on this panel. At least 2 judges that are on this panel right now would have been on the 3-judge panel to hear this originally, and the state would have lost their case. That's the reason that they took it and they went to the whole 15-judge en banc panel. Hold on, I'll show you off reels. Keep holding it. Keep holding your wood. There you go. But that's the reason they took this case and they went to the en banc full court panel, because they knew there are way more anti-gun judges on that full panel than there would have been on the 3-judge panel.
Yeah.
We've seen the 4th do it, and the 9th did it not too long back too.
What they're trying to do is they're trying to obfuscate Bruin and add a 3rd step.
Yes. And they're trying to delay it because, especially
They know they're going to lose. That's why.
If Joe Biden and his crew wins in this next election, then the composition of the Supreme Court will flip, and then they'll push through all of this stuff through the court. The court will completely uphold all this unconstitutional bullshit, and they'll get everything that they want.
So I was going to have dinner with Joe tonight, but Joe wussed out and decided he was going to drive straight to the hotel instead.
Oh, well, there you go.
So just FYI, Joe wussed out tonight like everybody thought he would.
Joe's wuss.
You might think that's wrong, but that's what Bruin tells us, right? And the how is fundamentally different here, right?
but I think look at Bruin footnote 9. The destination is how they got there. And they did that same analysis.
But what I'm asking is on Judge Quattlebaum's question. If
No,
for a
AR,
minute
dude, you're
you
good,
were
man.
required
You're
to
like
provide the actual
zen
analysis,
compared to this chaos.
not what some want.
Yes,
to believe
I'm
is a
Gabriel. That wasn't M1
presumption of
carbine.
Constitutionality that's
Yes.
like dropped in from
That
heaven,
that
right?
that was made
But
whole
instead, you
by
actually
Mark
have gone
Novak.
through in step 2 test, right?
The
You
Saint
don't have an
Mark Novak.
analog. I understand the step
Saint
1
Novak,
argument,
yes.
that might work, but what I'm struggling with is if we're in step 2, if Rahimi tells us that these questions about people are only a step 2 question, do you have
Still
any
going over
analog
Rahimi?
other than after the fact punishment?
Well,
Do
he's
you have
talking about.
anything that's ex ante that requires licensing or limitation?
All right, let me pause this here for a second. So he's talking about Rahimi because Rahimi, again, is a case about who has the right to carry guns, who is part of the people. And Rahimi, with his stuff, wasn't convicted of stuff. He was under some protective orders, but he wasn't convicted of anything. So he was still part of the people. The people should be defined very simply. If you are out on the street walking around and you are not in the government's custody, you have all of your rights. That's the way it should be. So they're talking
Yeah, I
about
guess so.
Rahimi adding a lot of that in this case. Why are you stopping my hand? Why?
I'm in a mood. Hit me, motherfucker. I'll knock you out.
You guys see me get knocked out on the stream.
You need to get the water bottle out.
Realize
Spray-
I'm
spray
married
it
to a
down.
redhead, and I probably had that shit coming.
You did.
Yeah, well, this is true. But yeah, that's the reason they're talking about Rahimi so much in here, because it was a definition of people and law-abiding people.
Bob is also asking a point. Rahimi has yet to be decided, right?
Yeah, Rahimi, the decision of Rahimi has not come out. And
Huh.
remember, this case happened today. These oral arguments happened today. Rahimi, June or so, when they normally put out their opinions, is when a Rahimi should come out.
Yeah.
Something like that, when the Supreme Court normally puts out their decisions. So that's why they're arguing so much about who is the people. And that's where Rahimi plays into that. And it's legal wrangling for them trying to delay the damn decision.
Or is everything after the fact?
As you said at the original argument, we couldn't find any laws that require advance permission. But there's a robust historical tradition.
Yes, Bob, 100%. That's where that comes from. It's 18 USC 922.
But why did, so just
D8.
last question, then I know lots of people have other things, but how does that satisfy Bruin's demand? Not just that the why of the
Y'all,
analog
I
is the
don't
same,
have
but
your
the
email,
how,
so I will
the
post
mechanism, the
it in
how
the
has to
chat.
be the
Jump
same
in.
too. And those are two fundamentally different hows. Everybody agrees.
No, don't give him a link. He never
that
gives
if
me a link
you
anymore.
Are not a law-abiding
Well, that's
citizen.
'cause
and
you're an
you
asshole.
Go buy a gun. You can
So
be
are you.
prosecuted, right? You can be prosecuted as a felon in possession.
But I'm running the
There's
chat.
no doubt on the back end that you
I give
can be
you
prosecuted
links.
for not being a law-abiding citizen and
I'm not
unlawfully
saying you're
buying a gun.
smart.
There's a robust tradition for that.
I never said I was smart
Well,
either.
there's
Well,
no tradition.
maybe smarter than your average bear, but that's
ex
about
ante
it.
Precluding people,
This is true.
placing the burden on the people to establish their
There's AR. What's up, brother?
pre-existing
Hey, man,
right to
doing
own
good.
firearms.
Yeah. Link
How
is
you liking listening to this so far?
They're pinheads.
Well, you're way nicer than I am, as always.
Jeez.
well, how do you think you get to be a Supreme Court justice? You have to be a pinhead.
Yeah,
Pretty
true.
much.
Mhm.
I'm.
Of course, that's a
coming to the
nicer way of
opinion-
saying it.
Yes. I'm coming to the major opinion, especially after the last year or so of listening to all these oral arguments. To become a judge, you have to relinquish all of your common sense, your belief in the common person being an individual, and you just have to brush your teeth with boot polish and be a statist.
Yep.
Well, technically, a judge is supposed to
Fun
make a decision based on the letter of the law, and
Yes.
in the history of the law, not based on feelings and opinions of feelings.
Yes.
Mhm.
But what do we hear in these oral arguments?
The problem is, what do we hear from the left leaning judges? All we hear about is bleeding heart opinions with no
Yes.
actual facts, with no history behind them.
Yes. and I'm sure we'll hear more as this goes on. We got a little bit longer to go because when this is over, I'm done with this. But yeah, we'll hear more of that. I'm sure. There are shootings and these bad people are doing this stuff with guns. Never mind all the people that defend themselves with firearms all the time. Screw them.
I know.
Thank you, M. Gabriel.
Logic and common sense, man. They just go out the window when they throw that black robe on, like 90% of the time.
Honestly, when it's the government talking about guns, it's already out the window and down the street on the garbage truck, because that's how the government is.
Yes. You got me there.
Well, the Supreme Court claims this. They don't go by their own political bias. This is the law.
Bullshit.
I mean, that's what they claim. But if you look at some of the rulings of Justice Roberts, he's always trying to straddle the fence or get in the middle or try to make the court look better. Or and it's obvious. Yeah. So.
Roberts is one of the worst. He refuses to just take a stand. This is what the Constitution says, and if it doesn't fit into this framework, it's not legal. Roberts is one of the worst.
He'll rewrite it.
Yeah. This is like the whole thing about Obamacare, whether it was tax, whether it was this, whether it was that. And,
I'd rather have Roberts than Ketanji Brown.
I think it was the biggest mistake in my lifetime putting him as head of the court.
Yes.
Totally unqualified, in my opinion.
Absolutely.
Status. It just goes that you can prevent that same person.
No, because it's fundamentally different. Because
Brooke, what's up,
what you're saying is you can prohibit me from buying the gun too, right? Merely because I'm a person of unknown moral character. Might be true, but right?
Assuming that you are law-abiding and responsible,
that's
Maryland
true, Brooke.
cannot prohibit you from getting it.
You can for 6
No,
weeks.
no one's
Right? You
completely
can keep me away for 6 weeks. Same thing with the Fourth Amendment. I think under your view, the Fourth Amendment would tell us you can just detain everybody.
And let's hit that real fast. So
no, it does not say that.
So getting to Brooke's point, no one is free of their bias, right? However, if your bias doesn't fit into the text of this Constitution, this state Constitution, your bias doesn't count.
Yeah.
Your bias should be shot down like a freaking Japanese zero at that point. It should just be in flames.
No, more like a Messerschmitt.
Yeah, Messerschmitt. Either one. I mean,
hey, I know my World War
although those are really cool freaking planes.
Well, their engines were cool, but the design. Yeah.
Well, the Japanese Zeros had it because they were light and they were really maneuverable, but their armament, not so much.
Well, everybody says that, but we all know what car company made the Japanese Zero.
True, Bob.
Mitsubishi.
Yes, that's what I was about to say.
Mitsubishi made the Zero.
Alito would have been a good Chief Justice, but even Alito.
And I haven't seen them make cars in years. All I've seen is them make air conditioners these days.
Oh, yeah, they've definitely moved into that.
Yeah.
But Alito would have been good. But Alito, to be honest with you, like in the Heller decision, Heller 1 and Heller 2, he completely punted the decision. That's where we deal with this language right now that the Second Amendment's not an absolute right. That whole opinion should have been like a paragraph long. It says shall not be infringed. The government doesn't have this power. The government can't do this. The government is completely wrong. I could frame that around a whole lot more intellectual situation, but that should have been the framework of it. Instead, you get into this, well, you could ban these don't fall into this purpose, and what about this purpose? And
I've got an answer for chessboard.
What?
Why are there 8 states that do not require a law degree to become a judge? Because there are in certain states, if you can pass the bar test to become a lawyer, you do not have to go to law school. You do not have to get a law degree.
Makes sense to me.
Alabama law.
If you pass the bar exam, you can become a lawyer. But in some states, they don't have that. So you have to pass the bar and on top of having a law degree to become a lawyer. That's why. And believe it or not, in order to become a judge, you have to be a lawyer. at some point.
You know what's weird about these modern times? We have drilled in for decades that you got to have a degree in college. You got to have a degree. Abraham Lincoln did not have a degree. A lot of people that run big businesses didn't have degrees. That now I think they're starting to realize. I was reading a few weeks ago that certain companies, big companies, they've dropped degree requirements.
A lot of them have.
There are elected judges, but the problem is most people who are elected as a judge, like the Supreme Court, they're nominated. It's a type of election, but only by like the Senate and and the House of Representatives. But the point is that if a judge is elected, they still have to be either a lawyer or a judge somewhere else first. Period.
Well, yeah, and if you've ever watched the confirmation hearing for the federal judges that Biden has put up in the last little while, they are some of the most incompetent people on this planet, but they agree with him agree with his ideology. So of course they're getting pushed through, and the vast majority of these Republicans on the House or the Senate judiciary will just vote yes on them versus being like, no, there's no way in hell.
I'm dissatisfied that we have to have so many damn lawyers in our government. Okay,
that's actually the problem with government right there.
If you look at the what is it, Continental Congress, the original founding fathers, not all of them were lawyers. Only about a quarter of them were actually lawyers. The rest were inventors, landowners, farmers. They were, businessmen. They were all walks of life. But now we've come to the point where only lawyers get elected, or super famous people.
Okay, M. Gabriel says Kagan was never a judge before being a justice.
Wow, I didn't even realize that.
I'd have to look her up, but Kagan's an absolute moron.
I always thought you had. I was always told you had to be a lawyer. You had to be a lawyer to be a judge. So if I'm wrong, I'm wrong. That's fine.
That's what I thought too. Yeah.
Well, but any judge
typically
absolute authority on either a state constitution or if they're a federal judge, they should be an absolute authority on the federal constitution. Yeah. And Kagan ain't.
As a plot to do something bad. And so for at least 30 days, we can detain everybody in the room. Fourth Amendment says, because there's somebody in here, we know with certainty that somebody in here is submitting a plot. Or you might say, we might just guess that somebody in here has a plot. And so we're just going to lock everybody in here up. The Fourth Amendment says that's fine because we're only locking them up for 30 days.
Night strike plots the same as wood.
And we're going to do that to prevent a plot. Plots are bad.
When you have it, but it goes back to the point that you, assuming you're law-abiding responsible, can get a gun. You say that you can't for 6 weeks or however many, the time requirement. And that goes to the infringement. So we go back to the text. We go back to infringement.
All right, you go back to step one. I totally understand the step one argument, but we're trying to talk about the step two argument. Assume Rahimi tells us it's step two.
Then we have the historical tradition.
So are you agreeing or disagreeing with Judge Richardson's premise that the mechanism?
I wished I could see who's saying these words.
Or is the question a comparable burden? And what's your position on how comparable the burden has to be to the historical analog?
And I would probably have to go find the transcript for it when they produce the transcript to see which judge is saying
first step textual
or the subtitles.
It goes to whether it's been infringed. Especially
I don't even think the subtitles cover it.
Where someone is not who is law-abiding responsible and otherwise is substantively eligible, will get that firearm. We're not dealing with something like
no, we ain't got it. We ain't got subtitles.
No matter what you do,
if I'm not mistaken, isn't it the Commerce Clause is why they have always justified gun control?
Yes,
is that individual ineligible? That's what I was thinking.
Since the 1934 NFA, most all gun control is based off of the Commerce Clause.
That's what
the 1934 NFA is all based off the Commerce Clause. Okay. And that came from a court that a couple things. One, they started to go a little left. Two, they didn't want to get packed because the president at the time was threatening to pack the court if he didn't get his way over a lot of stuff with the New Deal and all the other stuff going on. And there were one or two decisions before then that kind of fed into it. But yeah, if you read almost any gun control law, federal gun control law, you'll hear something about whether it travels in interstate or foreign commerce.
Mm-hmm.
And that's where you get into, hey, we're the federal government. We have the right to regulate this.
So we'll go after guns.
Yes.
And that's the way it's been. Yeah, that's they even, I think the Commerce Clause is, no, that was tax clause, Obamacare was. Or,
yeah.
Or what? Yeah. I'm wrong on that
The
one.
state should be allowed to determine whether that person is eligible.
Yeah, it's a mess.
Under that substance.
Congress has abused
Don't we have to
things for
compare
years.
Both the justification and the burden.
Yeah, Bob, I think I remember
to
that.
the
She
historical
was.
analog if we're at step 2.
Oh, okay.
It has to,
Dean.
we have to measure it somehow, how comparable it is to the historical analog, right?
But
Even though the court said that doesn't have to be a twin.
So if you can teach law, you must know law. Well, yeah, by the book.
There's some measure
But
that we
how
have to
can she teach it by the book when she don't
We have to
rule
look it
by
up
the
and
book?
Okay. Biden
So
said he
the burden
taught
relates to the
constitutional
fact that
law.
These folks are ineligible.
Did he?
Or could be ineligible.
Yes.
for possession
Or was it
of a firearm.
Obama?
The state has to have some way of
Oh, hold on.
figuring that out.
I don't know. Biden's been in the government for like 40, 50 years. How can he teach anything?
Biden's been known to lie about a lot of stuff.
Yeah. Biden in a speech, it has to be like 2 weeks ago now, said
Right.
he taught constitutional Second Amendment law for like 12 years.
Really?
He said that in speech.
I'd like to know when, because he didn't do it under the Reagan years when he was young.
No, because he was in the government during the Reagan years.
Yeah.
Hold on. You guys are going to make me find some shit.
Yeah.
Give me a second.
I'd like to know when he found the time.
Yeah, when did he
Sleep
find
down,
the time?
America.
I mean,
No. Was this when he didn't get elected and he was teaching Hunter how to go around and bribe people and get crack?
give him a free Corvette to drive on
Right?
top of
Yeah,
it.
hold
Which
on.
I love them, but still,
They're not made in Bowling Green anymore, so
I gotta find it. There's a couple stories busting him out on it, but I gotta find him.
He's known to do plagiarism too.
Oh, absolutely.
from time to time,
absolutely.
yeah. That's why he lost the presidency. I think it was in the 80s or 90s. I can't remember.
Well, here we'll do,
90s,
we'll do
I think.
this one, and then
Yeah.
we'll get back to the oral arguments. But
Okay.
hold on, I got to get past the commercial. But yeah, he said he taught constitutional law, the Second Amendment.
I
Let
don't
me
think
share
that's
this back.
correct. But
No, he didn't.
no, he didn't.
and in my opinion, Obama was never a constitutional lawyer either, according to my research.
In 2020, up at Independence Hall, democracy is at stake, folks. Our democracy is under attack. And we got to fight for it.
All right, here it is.
I taught at the University of Pennsylvania for 4 years, and I used to teach political theory. And folks,
This is political theory.
you always hear
Now, there's one
every
he says he
generation has
teaches
to fight for
constitutional
democracy.
law.
Okay,
Yeah,
it wasn't.
that's political theory.
Okay,
Okay.
I looked it up. He was a teacher from 1991 to 2008. He was an adjunct professor. He taught constitutional law at Widener University School of Law, but that's not in
Jeez.
Pennsylvania. That's in Delaware.
Trust me, if you are an adjunct, you can say you teach a lot of things and not teach them.
Mm-hmm.
I
That's
work
my-
for college.
I know, but that's what it says.
I know. I'm there. Where I got to find the exact quote where he said he taught the Second Amendment for like 12 years. It's hysterical.
Precluded from
True, Bob.
not being able to prevent an 11-year-old from getting a gun.
But is
On
it
the
enough
front.
that they could be ineligible? I mean, somebody in this room could have a gun, right? Hard because they came through metal detector, but let's put us in an auditorium. Somebody could have a gun.
It's a
But
good
nobody
question,
thinks
Bob.
we can go search everybody, merely because somebody could have a gun. What you're saying is the state of Maryland can deny everybody the right to get a gun for 30 days because somebody might be doing it unlawfully. Like we wouldn't allow that in any other constitutional context. No other constitutional amendment would we allow the roundup of lots of people, the denial of all permits for protest because somebody was going to use them.
I got to find this judge's
We all
name
did
because he
walk
was
through
good
what-
in the hearings
most of us
yesterday.
on
too.
this side walked through the magnetometer
Yeah.
this morning, even though there was no indication that
You know,
we
I
were possessing
counsel
weapons.
my friend
God,
Judge
that's
Richardson makes a good point is he always does, but I don't see the limiting principle to what my friend has said. Because every regulatory requirement
This is what
is
throat
going
cancer
to
sounds like.
probably by necessity apply to all of those.
Coop, this
who
is you another
it
20 years.
regulates. And that is the definition.
Although I'll never
of a
be that stupid.
regulatory requirement. And every regulatory
I don't
requirement
know.
is going to shift the burden on.
Dude, I couldn't be on life support and
to
brain dead to
someone
be that
to
stupid.
prove that they conform
I don't know.
with the regulation. And so what I'm concerned
My
about
brain
here
waves will literally
is that the
spell
arguments
FDATF.
that are raised against this particular regulatory requirement could be raised against any regulatory requirement of firearms at all, on the grounds that it impermissibly shifts the burden to the people.
I thought that was like a smaller island
off
off of an island.
over-inclusive.
No, that's an atoll.
And so between
Where's this guy
this
from?
over-inclusiveness argument and the burden shifting argument, you have knocked a whole host of regulatory requirements out. There's no limiting principle to this.
I agree.
Gabriel,
and
that
I
would not
point you
surprise
to
me.
Voter registration. We have voter registration to ensure that folks are of proper age, perhaps have are not felons in certain jurisdictions, live in the jurisdiction that they're voting in, even though you may satisfy all of those requirements on the front end. And I think that ultimately, I think Judge Wilkinson, what you're
And
getting
yes,
at
Jess,
is what
you're
this case is
100%
about. This
right.
is an infringement
They
case.
teach
An
us, they
infringement
use
as
hypothetical.
to and implicates Bruin's footnote 9 about excessive wait times, exorbitant fees, which of course are not present here.
They've turned college into a joke.
How about
too.
two processes? There are two processes. You have to get a license and you have to get a permit. Both take time. And the question is it violate the Second Amendment to layer the processes to try to satisfy whether a
The answer
person
to that is
qualifies
yes.
to own a gun?
I don't think so. I think where they complement, to get back to your question from a while ago, they complement each other because you get the license on the front end, and then you may not buy a gun right away. You may buy a gun 3 years from then, and then it allows the
I understand how it works. You keep answering me with how it works. I know how it works. I've read the statute and I've read the permit requirement.
Well, hallelujah.
The question is, why do you have two requirements up front before somebody can own a gun or purchase a gun?
Because they want to delay it.
And the question is that part of a step one or is that step two? It sounds to me, if it's step two, it's pretty unusual. I'm not
You're
sure
not
that
the
you have
only one
any
to say
animal
that.
that would require somebody to go through
You're
two
the
separate
nicest one to
processes
say it, but not the
to
only
buy a
one.
gun. He cannot go in that store and buy a gun if he doesn't have a license under the Maryland scheme. So he has to get a license. And then once he gets his license, then he still has to apply for a permit for that gun. And the question is that available anywhere in the United States now? You know, the footnote 9 talks about 43 states, but those permitting states, right?
correct, and some of those states have lengthy wait times or lengthier wait times.
I'm not talking about the length. I'm talking about, you got to get to my question and it would help because if you can allay my concerns, it would be wonderful. But my concern is a double process, a bureaucratic process that takes time. You have one that gets a license and the other gets a permit. And the license takes time and the state has up to 30 days under the statute to do that. And then you have the permit after that. And so you're going through this bureaucratic mess to own a handgun.
But if I can answer your question, the second one.
Yes,
is not
Chess,
a
you're
permit.
100%
You
right.
Go in, you show your HQL, you pick out your handgun, and then you have to go through.
You have
the
to get a
7 days.
permit. You have to get a permit for that gun.
I don't think that's accurate. I think in this, there's
What do you
one-
get under, what do you get? You have to go through another process, right?
Yes,
All right, that whole process, what is that designed to do?
and what you get is a handgun.
No, I said, what is that designed to do?
It's designed to allow a background check to be
All right, and
facilitated.
did you do a background check also on the first step, the license?
Yes,
All right, so you have a background check on the license and a background check on the permit. What's the justification under the Second Amendment for that type of process?
The justification is the same, which is to prevent those who are.
How about if we added 3 or 4 more of those processes?
All right, Cooper, I'm
Would
jumping
that
out.
be
All right, brother
violation
man.
of the Second
Catch you
Amendment?
after a while.
Let's add 4 more.
Later tonight.
Well, I don't know. I think that'd be a challenge. The concern here is that they are not.
So if we had
challenging
6
77.
processes you had to go through, you think that might be a challenge?
I think at some point. that's
Sometimes
what
they
we're-
talk to them like they're
These
idiots, and I don't think they pick up on
challenges are
that.
Subject to
No.
infringement.
I mean, they're
level of
you can
infringement.
tell they're talking to them like they're
A
idiots.
factual question,
I
Mr.
mean-
Dietrich, so, and maybe this
Judge, if he's the same one, he's the same one from yesterday.
is Niemeyer's
During the assault
concern.
weapons ban
Is
hearings.
this
He has
two-step
been
process, the license and the permit process, does that apply even if someone gets the license and that same day goes down to the shop and buy the gun? They have to go through that.
Yeah, Bob, we're going to
process.
give background checks until you give up.
I mean, I can see the
That's about it.
rationale of someone, I think you were saying the hypothetical where someone gets a license and then maybe a year later applies for the permit because his background might have changed in that period of time. That would make some sense, but it seems to make a little less sense if you've got sort of an overlap of an immediate license followed by a permit. I don't see why you would need 2 background checks for that.
Mr. Dietrich, let me ask you this question. It's a simple question.
Oh, God.
After
we're
the
this,
licensing
dude.
process is completed, after that is completed, what is it that you need further?
I want to say something since we're on background check.
versus a law-abiding?
Did you
Yeah, let
know?
me pause this and say what you got to say. Give me a
After
second.
that process is over.
There
Did
go.
you
Say
know?
what you gotta say.
Because of a little thing, and I don't usually talk about this, but there's a little thing I did years ago, decades ago, that got dismissed in a court that my whole life followed me in the NICS system once it was established.
Yes.
And I've actually picked up the phone and called them, and I said, "You need to straighten this crap out." Oh, we see it, Mr. AR. They told me in '97, I think, we got it now, right now. It'll be okay. And that's after years and years of turning me down. Now, I did have a permit in the 1980 in one county. I went to another county. They turned me down for a permit. I just finally gave up, didn't have a permit for quite a while. I still carried a gun, but it's weird. So what I do is, because Georgia now, when you get your license, you don't have to worry about them background checks. I just got my concealed carry all the time, even though I don't have to now. And I get guns all the time if I want one. But that little thing interfered through most of my life as an adult, always put me on hold or delayed me. I was never denied, but always on hold. Yes. And so that goes to show what that NICS does to you. And I didn't. And what I did was, put it this way, it was throwing a rock.
Dude,
throwing a friggin' rock.
I know a guy, which he's been up in Oregon. He's up in Oregon forever. But he got in a domestic violence situation in Georgia.
Mm-hmm.
And all charges were dropped. It turns out the bitch is crazy, not to use too bad a language. It's my channel. But it turns out everything's dropped. He was never convicted of anything. He's been in Oregon forever and then tried to buy a gun in Oregon, and all that comes back on his background check. And it took him over a year just to get his AR. Something simple.
Wow.
Because he had to keep going back and forth. Hey, this was a situation I was basically wrongfully accused of something that never went to court. It was actually dropped. In other words, they figured out it was bullshit. It never went to court. Now this stuff's still on my record. It's been chasing me around for 30 years. And now I can't pass a background check in Oregon to get a gun.
My situation was the same thing. It followed me around. It was never went to court. It was all dismissed. And actually, when I called the NICS people, they admitted it was dismissed. They said the record shows. Yes. But and I said, well, by golly, you keep turning me down, put me on hold, or, I said for, whatever, 10, 20 years. So I just got fed up with it and got the permit.
Yes.
And
did they ever give you the option to get the PIN number for your background checks?
No, not here.
Because there's a PIN. It's a federal number. You can get it. Because I went through that when I got delayed on this last FFL transfer that I did. I could have gone through and could have got this PIN number, and I could use that PIN number on all my FFL background checks, and it's supposed to basically include all the history and be like, okay, this dude's got his PIN number, he's good, should speed everything up. UPIN, yeah, Gabe, I think that's what it is.
Wow,
but that's still horse crap.
Yeah, I've never heard of that.
Yeah, it's there. I had to do when I got all my rights back, and for people who, everybody in here should have heard it already. I was a convicted felon for well over a decade, and then got all my rights back. And the first FFL transfer I went through clean, no issues. The second FFL transfer I went through, no issues. The last one I went through, all of a sudden I'm delayed, denied, and then pending, and all this other BS. And they offered me the option, hey, you can get this UPIN number. No, one, I don't want to. You guys already have my social security number. You guys can find everything about me by my name, birth date, and social security number that you need to find. So I'm not looking for this UPIN number, but they throw this UPIN number out because a lot of people in ethnic groups have the same names and they tend to get hung up on the same kind of charges. Well, this birth date doesn't match, but this name does. And it's a bunch of horseshit. And it's just another way for them to throw a roadblock in your way to make you jump through that many more hoops to actually be able to, practice your rights.
Yeah.
We were lied to from the get-go when it came to the NICS system.
Yeah, years ago, my brother come to me. He was a NRA guy. He tells me, he says, well, this is what NICS, this was in the 90s. I was still young and having a good time in life. And he says, I endorse it. I approve of it. I says, I don't. I said, what are you talking about? And I said, if that system happens, man, I said, one day they'll turn it into a database. And I didn't even know much about a database back then, but I said, they'll use it against us one day. I said, I don't agree with it. I said, why? For 200 something years, we've always bought rifles and never had to show our license.
Yes.
And I didn't agree with it. Put it that way.
And now look what it's become. The ATF has over 1 billion records, 1 billion records of firearms transfers that they can search through at any given time. This is how they show up on your door. You go to buy 2 or 3 guns in a month or something like that, and all of a sudden you got ATF knocking on your door. Wait a second, you bought 3 handguns this month, or you bought 2 rifles and 4 handguns this month. Where are those guns at? What have you done with them? And there's video out there of that actually happening.
Yeah.
And if they show up on my door, you bet your ass it's probably the only time I'll be videotaping during something like that. But I'm going to
you don't. If they show up, you don't even have to. You can talk to them to the window. You can tell them go get you a warrant. They won't go get a warrant, but what it is, Biden administration is sending them ATF, and I think it's a lot to make it more the norm, precedent.
It is
in the country to get people used to it. But I won't if they come here because I bought 2 guns. I'm gonna go, bye. I mean, I'm not going to be mean. I'm just going to say, sorry. I don't talk to the federal government. I don't talk to ATF either. Bye.
Yep. I'm not opening my door. There are windows on either side of my door. If I see who's there, no, I'm not opening my door. I'm not talking to you guys. If you want me, you send me paperwork. I'll get a lawyer. I will talk to you through a lawyer. That's it. Now,
and the more we do that, pretty soon they'll give up on this crap. I believe in time, hopefully, somewhat.
I don't think they'll give up on it. I think they're going to keep pushing the issue, but it will make it harder on them.
I do too, to a point. Yeah, I agree.
Yeah, I think it'll make it harder on them, which anytime I can make stuff harder on the federal government, I'm all about that.
Heck, I get upset here, and even in this rural town, I'll look up and there'll be a DHS car pass me. And man, when George W. Bush did the DHS, I said, has he lost his, damn mind?
Yes, he did.
I mean, geez, another bureaucracy, another government agency over us.
And I was so young and dumb at the time. And when I heard about it, it didn't bother me. Now it drives me ape crap.
That inquiry, whether they're a law-abiding person. After the licensing, what's missing?
Damn, Brooke.
I believe the license allows the state to be satisfied.
I didn't say it.
Pass the background check and is you a law-abiding, responsible citizen.
I try not to use that word. I have a time or two in my life.
Brooke, you got a wrench. Post your channel in the chat, please. And Brooke is the most level-headed person you will ever listen to.
Well, we don't have.
I've watched her. Yeah,
That's necessary
I like her.
to make this
Good.
determination.
Brooke is
I'm
outstanding.
just asking you, what is bereft in that process?
Way more level-headed than me.
That you need to go to the next, which you call permitting. What is that?
It's my understanding also that the 77R process serves as a waiting
No, but
period.
see, no, you don't, I'm just asking you, what information, because this is about information, it's so simple. You may go all around the bush, I like to do things straight ahead. It's information you need, right? Correct?
As I understand this,
You need information, right?
Yeah.
This is, it's not a trick question. You need information, further information, correct?
You know who the first one in Congress started talking about all this database and computers?
Who is that?
Newt Gingrich.
I may have got,
Of all people. Yeah, we got a computerized Congress. We need to computerize medical records, he said, decades ago.
Process, right? Permit process.
That makes sense.
Pisses me off.
I would disagree. I don't think the second step is a permit or a license. There's one license, one permit, and then there is a 7-day period.
License, and then they have to have a permit from you.
He's asking, why can't you get a gun after you get a license with nothing more?
Because of the presence of the 77R requirement, which is not being challenged in this case.
That's not my question. My question is more.
Our local congressman here, Andrew Clyde, he's in, at least he was in Congress. He owns a gun store here in Athens, Georgia. He's trying to fix the NICS too, Brooke. Wants to. And actually do away with it, I think. But
so after you have a license, you just said that a background check is done at that process, right?
That's correct.
You do fingerprints at both.
No, the fingerprints are only on the first.
Right.
So you've got the background check and you've got the fingerprints. And when you actually go into the store.
That's correct.
So I'm asking, that's all.
Okay, because I got to pause this because AR, since you mentioned it, Andrew Clyde is the one. He had his own gun store. And, you know, the reporting requirements for banks is if you put more than $10,000 in the bank, they have to report it. If I'm remembering this right, so take it with a grain of salt. Andrew Clyde was making sure that all his deposits fell under $10,000 every time. And then the government came in and said, wait a minute, that's structuring. And they confiscated his bank accounts.
True.
With no proof of a crime and said, you're not getting this money back. And he spent millions of dollars getting his bank account squared away and getting his business back on track.
Yeah, he was on Fox years ago. He talked about that.
Yes.
He don't like the NICS system. He says that a lot of people up here, not far from where I live, they have to wait, 30 days, this, that, and the other, and he's furious about it. He has a really super nice, large gun store, boy. FBI is in there, all the federal agencies trade in guns. It's bigger and better and good prices compared to any other gun store I know of, actually.
I need to stop by. I need to look up his shop and stop by it one time because I'm not real far. I mean, Atlanta, for me to make it to Atlanta is probably about an hour and a half. But I need to stop by there one day just to do it. Even if I just go buy a damn sticker or some ammo, some ammo or something like that. But yeah, I've watched Andrew Clyde in a lot of hearings and then did some research on his story through some other shows and stuff that I did. And yeah, he knows what's up.
Yeah.
He got good prices too. He'll sell an AR-15 for like $400 less than the next mom and pop down the street.
A background check.
Damn, nice.
Yeah, he don't rip you off typically.
Why the second background check at that point? Why the second? Was it 24 hours passed?
I think the rationale is that you get the license and then you get the gun, and there might be time that elapses between those two processes.
Let's do it at the same time, Judge Diaz asked you.
Is that what you do? You bring it up from bring the
HQL card, or you can have
the
it.
criminal
sent-
check current. You have to know at the moment they get the gun that they don't have a criminal record.
They show the card, they got the handgun, and then that starts the 7-day process, during which a background check is.
Does Maryland have a expedited process for background checks and fingerprinting? I'm wondering because you do backgrounds and fingerprints here, bring in employees like clerks. I've never seen it done in 30 days. I mean, this is pretty fast. It sounds like to me. And I don't know what kind of background check are you talking about? You talking about a federal one or just a state background check? Because it seems like to me you need both. And I don't know how in the world you get something to the federal government to give a background check within that short a period of time. We need to know at this court because we hire people here all the time. And it's pretty important for us to know who we're hiring and whether or not they have those things. It's pretty simple on it. But I'm curious. This is a pretty fast process you're doing here. You have some expedited process of doing this?
I believe it involves.
Yeah, Bob, that was another one.
State records, federal records, mental health records, and can be done within.
What
as the
about
record shows,
fingerprints?
True,
Is
Bob.
it up to the
Isn't
citizen
it
to get their fingerprints taken and they have to pay for it? It's not done by the state.
That's correct. An applicant has to get their fingerprints taken and they're responsible.
You know why it's happening? They don't trust us anymore
Mr. Dietrich, does it?
in modern
Oh,
day.
You
well.
can help me with this on the sequencing.
They're
A person
paranoid
could
over
have
us.
an HQL license for a period of time, isn't that correct?
That's right, up
It's
to
not
10
time
years.
limited. So they could have an HQL for a period of years and then decide they want their gun.
Or get a second
And
gun.
then the 77R kicks in.
Oh my God, a
and
second
does the
gun.
update. Isn't that correct?
That's correct.
Okay.
1, 2, 3. Never mind, I'll quit counting.
Getting of the fingerprints is something the applicant does?
That's correct.
And how does the state have control of the time when that is done? I mean, if a person comes in to apply, they wait a month or two. I mean, is there a time period they can do it, or do they do it when they come in to apply? Or?
Let me tell you about a hypothetical process. Let's say there's a handgun qualification. There's
Now
actually a
Brooks
place
out
where,
there. Brooks got it together.
I've seen some of these places.
That's
that
why you
offer
got a
vocational
wrench,
training,
Brooke.
actually offer fingerprints. It's a state approved vendor, live scan fingerprint. So you can go to the same place, get your training, get your fingerprints. It's transmitted to the state police. At that point, you can, once you're done your training, once you've gotten your fingerprints, you can apply. That starts the 30-day period. Again, it's the ceiling. It's not a 30-day waiting period. It's just a ceiling on statutory cap on the amount of time that can go by. So the record shows all of them were completed within 15 days.
I have one last question, but it deals with the step one textual aspect. Judge Niemeyer alluded.
Yes, chessboard. Yep.
Focused on that. Is that there's that phrase, keep and bear arms shall not be infringed, and the infringement of it.
Yeah,
Seems to
chess,
be two different things
absolutely.
when you're trying to functionally determine are they part of the people, but are their rights being infringed seems to have been a focus here. We've been bouncing back and forth between the two of them, both in my opinion, textualist type considerations to determine whether or not that's being done. And which one is the emphasis here? If not both.
Both, Your Honor, because to determine whether a right is being infringed, you need to know the scope of the right. And you need to either know the scope of the textual aspect of the right or the scope of the historical aspect of the right. But what we do know from Bruin's footnote 9 is that regardless of whether it's text or history, it arrives at the same destination, which is that you can require individuals to show that they are law-abiding, responsible citizens to have Second Amendment rights or to be able to possess, carry, et cetera.
Are you checking only the state criminal record? Maryland's criminal record? What if we had a problem in Virginia? You check Virginia's record?
I gotta do a show on footnote 9 since I keep bringing it up. It's not necessarily what that said.
Your Honor, it's federal and state records. I can't speak to whether the extent to which other states' records are incorporated.
You're getting a federal record.
That's my
You
understanding,
just
yes.
mentioned the state record earlier.
Yes.
Mr. Dietrich, one question and follow up to Judge Wynn. What do you think the significance of, in footnote 9, the Supreme Court citing the First Amendment cases? I think it's Shuttlesworth or Cantrell, but they actually cite those cases in footnote 9.
Right, and I think what they're saying is it goes to the infringement aspect of it, the substantive limitations or the burden that one can put on the right and still, so that it's not destroyed. And I think and to go to
Think about this for a minute. Of all the things they go after, Congress,
shall issue,
what's the one thing that
no discretion
neuters them,
There's
and they know
also
it?
The idea that,
They know that an unarmed populace
It has to be narrow. It has to be objective.
is defenseless.
clearly defined
Yes.
criteria, which
Yeah.
is what.
Unarmed people are
statute
really
said
easy to
that,
put on the
the
trains.
State
Yeah.
had to issue
So I
the
find it
license
odd that
within
they
1 year.
just go after the Second Amendment. They don't go after the other amendments typically.
You have to go through this process.
Not to the
and
extent they
state
do,
has
yeah,
to
2A
issue the license.
stuff.
Well, you got to figure how some of these other things are used. So the First Amendment, my ability to speak, like now, our ability to speak. Okay, I can use that for all sorts of propaganda. I can use the Fourth Amendment against search and seizure. I can use that to protect criminals. Go figure. I can use the Fifth Amendment right to not incriminate. I can use that to aid criminals and keep them on the street. The one real right that actually limits the government's power and keeps them from having a monopoly on force is the Second Amendment.
Yeah.
So that's why it's a constant drill on that Second Amendment.
Mm-hmm. Yeah, Adolf Hitler said the streets are safe now. Everybody's unarmed and the police are here. I forget it word for word.
Yeah. Take it easy, Brooke. Have a good night, chick.
Night,
Within
Brooke.
1 year.
I think
Would you defend that as constitutional?
anything that relates to time, I believe, has to be an as-applied challenge. Because
Why? The statute on its face says it's going to cost you $7,000 and the state has up to 1 year on its face. That's what they don't have to do that, but that authorizes the state to do it. It infringes on the shall issue. In other words, it now gets into the realm of discretionary. But I'm asking you, we have a hypothetical statute, charges $7,000 for the fee and says the state has up to 1 year to issue the license.
I think we may have a problem with the cost because
You just may have a problem.
with the cost is ascertainable. The
Then
time
set
is
aside the
up
cost.
to-
How about the 1 year?
because it says up to 1 year.
Right.
I think it has to be an as-applied challenge. If it said up to 7,000, it would have to be an as-applied up to $7,000.
Why doesn't that implicate the issue of shall issue? In other words, may issue is not constitutional. We know that. And shall issue is constitutional. Now, if you have up to a year and the man doesn't have his gun,
I think the may issue aspect of may issue versus shall issue was relating to the specific discretionary requirement of the proper cause or good and substantial.
what's your
reason.
position on the 1 year? You have a difficulty in answering the questions.
I think it has to be if it says up to 1 year.
You say it's okay up to 1 year?
I think the statute can
On its face, I'm saying.
on its face is fine up to 1 year. Just like up to $7,000 would be facially appropriate. If it was $7,000, it's a different story. Here we have a statute that says up to $50, and under the First Amendment jurisprudence, the Cox versus New Hampshire, you say you can have a fee in terms of exercising a constitutional right as long as it relates to the cost of administration. And there's evidence in the record that the cost of administering and issuing these HQLs was more than $50. And so therefore the $50 cost was constitutional.
In the First Amendment cases that you're talking about, are those cases finding that it's not expressive conduct, or are those cases based on means in balance? Those cases are not finding that it's not speech, it's not expressive conduct under the text of the First Amendment, right? They're addressing this step 2, means and balance. But that's what the court is doing in each of those. That's the means and balance. That's why the court permits, protest licenses, for example, right? It's a means and balance.
I would agree with that.
Not that it's not expressive conduct.
Correct.
So in other words, step 2, not step 1 in the First Amendment inquiry, is where we analyze the permissibility of a license that requires 7 days or 10 days or 30 days before you engage in a protest.
I do occasionally, Bob, because I went to Grace.
If you're importing sort of step 1, step 2 into the First
I'm just
Amendment.
asking about, you talked about the First Amendment. You brought up the First Amendment. I was responding to the First Amendment. I just want to make sure I understand how you understand the cases that you're relying on. You say these are like the, permits for protests, right? And so that's like a good analog from your perspective. And so I'm just saying that those cases do it as means in balancing, right? When they analyze whether the time delay for a permit to engage in a protest, they don't say the protest is not expressive conduct. They say under some level of scrutiny, depending on the nature of the protest, right? It satisfies it or doesn't. That's means in balancing, right?
Right. And they've imported, if that's interest balancing, the Supreme Court imported.
Wait, why do you say if that's interest balance? I thought you just agreed that was means in balancing. That's interest balancing, right?
Right. But the point I'm making is the means and balancing that occurs there has been imported into the Second Amendment via Bruin's footnote 9 by referencing those. And in doing so says that for those particular aspects, the infringement aspects.
Footnote 9 says that we engage in means in balancing, like intermediate scrutiny.
When it comes to certain things like excessive wait times.
Is this happening in the state of Virginia?
The question that
No, this is Maryland.
Maryland. I was thinking it was, yeah.
So make sure I understand what you're saying.
I don't know why I said Virginia. Yeah.
Because it's right there.
Citation to the First Amendment cases is that
Yeah, I've heard about their issues for
decision
quite a while.
tells us we do means end analysis for wait times.
I think the import is that it's a different analysis. It sort of takes it outside of that historical tradition analysis.
Why doesn't it just say that it doesn't infringe the right to delay your ability to get a gun for a brief amount of time, the same way that it doesn't abridge the freedom of speech to say that you have to get a permit? Why isn't that the easiest, obvious step 1?
That's correct, and I agree with that, and that's what at least I think we've been trying to say is that this is about infringement. When we get to these wait times and we get to these administrative burdens, it's a infringement question and not necessarily a scope of the right historical analysis type question.
Can a corporation be part of the people in the Second Amendment?
I haven't thought of that.
Well, it's a plaintiff in the case. How about the individuals here? Have they already gotten their guns?
If he's talking about a corporation, then yes, a corporation can be an individual. That's been proven out in other cases. I can incorporate into a business. I am still an individual.
Mm-hmm.
I can have a limited liability corporation. I'm still an individual running that.
Individuals here?
I don't know. I
Certainly has an opportunity, I would take it. The wait time for them has expired for that point in time.
I don't know about the individual plaintiffs in this case. I mean, if they have, then the case might be moot, but.
We're not prejudiced. If there's been a wait time, they've gone through it, it seems like it might have already been, but I assume this is a facial challenge, so it's a different perspective. I was just curious in terms of the corporation because it's here.
I mean,
on behalf of its members.
I haven't.
All right, thank you, Mr. Dietrich. You're way over time.
Okay, thank you, Your Honor.
Mr. Sweeney.
I don't follow this stuff
Thank you.
like you do, but I do
Bruin and Heller
understand it,
both fiction.
definitely.
Well, dude, to understand a lot of this stuff, all you have to do is be able to have a rational thought in your head.
Yeah.
And understand what's right and what's wrong. You don't have to be a lawyer to understand this. lawyers are the problem. It gets so complicated and down into the weeds when something as simple as murder's murder.
Mm-hmm.
If you take someone's life wrongfully, that can be kind of different levels of murder, whether it's, a homicide, negligent homicide, first degree murder, second degree murder, but you understand the premises of it.
Oh, yeah.
Dude, I'm a welding instructor, and I am not the brightest bulb on the tree, but I can understand this. So
yeah, I read articles occasionally about Maryland. I understand what's going on with them, their control, or I think they have assault weapons ban too, right?
Yeah. Well, the assault weapons ban was argued yesterday.
Okay.
With this same panel.
Okay.
So some of these judges that we're hearing from today in the shall issue case, well, they argued two cases yesterday with this panel. One was the assault weapons ban. The other one was someone damaging serial numbers on a firearm. Both those went through yesterday. And then this popped up today with the Maryland shall issue. And this is all the same en banc panel, which is basically a representation of the full court.
Mm-hmm.
And I'm learning more about how that works as I go. Trust me.
Mm-hmm.
And
reminds me one time the cops, a few years back, years ago, actually, in the 90s, says,
to a shall issue regime.
I blueprinted or something. I forget what it was. I can't recall, but they looked at me and says, "We know your criminal record." I said, "I have no criminal record." And I walked out on them.
Yeah.
Tell me I had a criminal record. And the record was the one I told you I never went to court for.
Yes.
But he basically said they're not.
If you haven't been convicted, you don't have a criminal record. I was, which I pled out, but I was convicted. So I had a criminal record. I did. There's no lie about that. Because you can charge anybody with a crime. Anybody.
Yeah.
Okay. Cops do it all the time. Can pull past someone on the street and be like, I think this person did that, and can charge them with a crime. Then it's up to the DA to decide whether they want to bring it, in some cases, to a grand jury, whether the grand jury wants to indict. And in a lot of cases, it's been said you can indict a hamburger. So, yeah, just you being brought in and arrested, even if you were brought in, arrested, fingerprints taken, processed, that's not a crime. That's not a criminal record.
It was a smart aleck cop's response, what it was that day.
Yes, absolutely.
Yeah.
And that's what it comes down to. But there are a lot of people in this world that don't realize how easy it is to come into contact with law enforcement and then have handcuffs put on you.
Yeah, that's true.
And that's, especially today, with all the information we have in front of us, that kind of amazes me that people aren't that kind of plugged in or informed. Because there are a lot of people. Go ahead, brother.
In my day, cops used a lot of discretion. Now they tend to not. They just go by the book. A lot of them do, and I don't think that's right. You need to have discretion in doing it. But
it should be the fact, and I will support police as long as they are doing something that's constitutional. I will support any cop who says, "Wait a second, that's not constitutional. I'm not doing it." And it come down to hell, even COVID. When we looked at that, when you saw police arrest people for not wearing masks, and then if the people resisted arrest, which was an unlawful arrest, then they charged them with either assault and battery on an officer, or they charged them with resisting an arrest. And these people went through serious money in court, and some of them actually served jail time. I have to go find them. Over ultimately what was unconstitutional in the first place. That's when I don't support police.
Yeah. Barton Fink's right there on that Reagan quote. Crazy.
Barton's right on a lot, which hell, most of you guys are. That's why I got to give Chris a wrench while I'm thinking about it.
Reagan had a lot of wisdom in his sayings.
He did. Reagan had a lot of wisdom when it came to some things, but to be honest with you, when it came to firearms law and when it came to constitutional rights, no, Reagan wasn't If you could have plugged firearms and constitutional rights into his wisdom, he would have been awesome. And he was awesome on most things. But when it came to firearms and actual constitutional rights, Reagan was not that great. As much as I love it, you know.
My son brought that up once, asked me, because he knows all about Reagan. He says, so do you agree in 1992, I think it was, he said Reagan said he supports the assault weapons ban. I said, no, he was wrong. But yes. I'll say this, a lot of people don't realize, though, a lot of that stuff is in the context of the times, the stuff you're talking about, because Reagan in the 1990s, the AR-15 was not a common firearm for individuals at the shooting ranges. I went to the range. I never seen one.
Not as common. Certainly not as common as it is now.
Yeah, but, and so fast forward, I believe Reagan would have probably been supportive of it, knowing him. But at the time, no. My first introduction to AR was 1980, so that was when Reagan got elected.
Yeah, because Reagan coming in from 80 to 84. Then 84 to 88, and then we ended up with numbnuts coming after him, and then you ended up with Bush after that, and it was a whole rotation.
But our times do influence us, though. Is what I'm getting at with Reagan.
They do.
It did our founders, too. So
it's one of those things where if the text of our Constitution actually mattered, if the text of the Constitution actually mattered, then some of those things wouldn't influence us so much. Because even if we felt one way about something, if you looked at the text of that Constitution, you would go, well, it doesn't matter how I feel. And I think about that in the context of inspecting welds, because I have a code book, depending on which code book, whether it's D1.1, whether it's API 1104. Hey, my lights went out. Just depends on the code book I'm working out of. I've got to go by what that code says. It doesn't matter the way I feel about it. And if people did that with the Constitution, we would be in a lot better position with all of our rights. Instead of having judges who will shoehorn in their opinion into a decision and say, well, the state's trying to do this for a good purpose, and we're going to kind of shoehorn that in.
Yes, Barton.
It's It really does prove that what we are ruled by are people that are ruled by their opinions versus this document that was supposed to restrain these powers, whether it's state or whether it's federal. And that's where I have my argument with a lot of these judges.
Yeah, one that is not even at the end of the shell issue regime. So we have here a two-layered scheme. And we know there are no historical analogs because we're not talking about historical analogs. They point to the militia training. And what do we know about the militia laws?
The reason you're not talking about historical analogs.
Yes, Bob. I'm familiar with it. Most of his sayings I am.
It's not in this
My
case.
question is, where would you talk about historical analogs? Would it be step one?
Step two.
Step two. So you're saying we're not talking about them, and you're saying because we're not.
Well, because step one is, does it implicate the Second Amendment?
We're talking about step two. We're not talking about historical analogs because there are none.
Lynn, can I ask you, why isn't this just a step one case? So I thought of two examples. So the First Amendment says you can't abridge the freedom of speech, but we know that you're allowed to require permits, and that must be because
No, Judge, you are only allowed to require permits for speech if they are held in certain situations under certain guidelines. So like me getting up in the morning and speaking, or I call up AR, I'm not required to have a permit for that. Now, if me and our AR want to do a concert in the middle of the freaking Capitol, yeah, we might have to have a permit for that. It's only in very specific, it's the time or place restrictions where you would have to have a permit.
Yeah, they wasn't here, Rungan. Let me speak on that government. What he says was, I forget the first thoughts he said, but you better run if they come up and say, I'm from the government, I'm here to help. That's not a good thing.
Yes.
You better get, go.
Well, Reagan said that it was the scariest words an American can hear is, I'm from the government, I'm here to help.
Yeah, I forgot that first part. Yeah.
Yeah, that's and that's true because let's face it, our government doesn't help us.
No.
It's the biggest, largest, most successful criminal organization on the planet.
Buying permits does not categorically abridge the freedom of speech. The Fifth Amendment says you can't take property without just compensation. But the Supreme Court has repeatedly said that that limiting your ability to use your property for a period of time is not a
Jet lag does that to you. You travel a lot too.
So why isn't the right to bear arms the same? That it doesn't infringe the right to require a brief waiting period before you can purchase a gun. Why isn't that the easiest way to do this?
First of all, it's not a brief waiting period.
Sure, but that's an argument that's too long. And so the argument would be that it's just in the same way that at some point a delay can take. The Supreme Court says this in Tahoe. At some point, it gets so long it becomes a taking. Sure, but that means not every delay is a taking. Just like not every delay in your ability to get a gun is an infringement of your right to bear arms. Now, at some point, Bruin footnote 9 says, at some point it can get so long that it becomes an infringement, but not every delay is an infringement. Why isn't that a completely consistent way to read Bruin footnote?
Assuming you are correct, whatever interest the government has in requiring the citizen to prove they're part of the people is satisfied by the 77-hour process in Maryland and has been successfully since 1966.
So counsel, I thought your response to Judge Hytens was not going to accept the premise, right? Because the point that I thought you would make is that Bruin tells us that the question is a historical inquiry. And
Absolutely.
we know from the First Amendment context.
Man, I've enjoyed this, but I'm gonna have to run, Coop.
Go ahead and run, AR, but you're welcome anytime,
We
brother.
know
I
in the
promise
Fifth
you.
Amendment context.
Appreciate it, man. Good to hear being with you.
But it is
I enjoyed it.
historical inquiry.
Good to have
That's
you come
just
in,
not
bro.
what we're doing in those cases.
Good to
Maybe
talk
it's
to
what
Have a
we
good
should be
night,
doing
man.
in those
You too,
But it
man.
is
Y'all on the
not
side
what the
chat.
Supreme Court is
Have a
doing.
good one.
They're doing means in balancing in the First Amendment context, and they specifically said that's forbidden in the Second Amendment context. Right? They're doing an ahistorical analysis in Tahoe, right? And despite Cedar Point, we're not back to a historical analysis of the Fifth Amendment.
AR,
So
if you're still
I
in
thought
chat,
the
dude,
premise would
post
just
your
be,
channel,
the Supreme
please.
Court's told us that the Second Amendment is governed by history and tradition.
Let me pause this. Or any of you guys that have wrenches, dude, do me a favor and post AR's channel. And AR, I'm going to have to get with hopefully in the next little while. I've got a shotgun reloader and I've got a single stage reloader I can set up for rifle and pistol. And I've got to get with AR on that because he's one of the gurus. I got to order some dies here in a little bit, and then I'm going to become a giant pain in the ass for AR. But yeah, if any of you guys got AR's channel handy, go ahead and post it, please, because he's a good dude, and he doesn't cause the fucking pain that I do. AR is the guy I listen to a lot of times if I want to chill, I want to get on a subject that's interesting, and I don't want nightmares. That's AR, and he's a seriously good dude.
Tradition, not means in balancing or the ahistorical taking.
Correct. And when you look at the process and the burdens intended to it, you go into that interest balancing that was forbidden in both Heller and in Bruin. And
There
that's
you
what
go.
we're
Thanks,
doing
Jeff.
here in terms of talking about can't the state.
Counsel, I'm over here. I am confused.
Did she just snap?
As to what significance you think we should put on the fact that these are two separate processes? If it's just one thing. If Maryland said,
Thank you,
know
Chris.
what, it's going to be a maximum 30 days. You have to have, because they want the background check right before you buy the gun.
She seriously
So
just.
is your objection to the fact that these are two processes, or is it just an objection to having to do two different background checks? Do you know what I'm saying? If this was all under one umbrella program. and
Well,
it
two
said-
different background
and
checks that require some amount of time. So yes, the HQL is an unnecessary redundant.
Dude, this
process.
lady can't get away
77
from
hours
being an
sufficient to satisfy
insufferable
whatever
bitch.
government interests have been
Because she
mentioned
was
by
yesterday,
the
too.
They want
judges
the
who have
training
questioned me.
too, right?
Well, let's look at training for a second. There is nothing constitutionally justifying of a training requirement to acquire a handgun in the home. If you look at the militia training laws, that was training to participate in the militia. And that training was not required of citizens who weren't
But what about
participating
the
in the
part where the
militia.
citizen has to be a responsible, law-abiding citizen? Why doesn't training go to responsibility?
So
Is it-
responsibility refers to age. It refers to mental acuity.
Personal
It does not
responsibility.
refer to training.
What
And
is
we
the
completely
source of-
disagree that
Who
there
said
is any
that? I'm
constitution.
sorry, who said that? What's your authority for it doesn't?
Oh, this lady is
that
absolutely
responsibility does
insufferable.
not refer to training. Say it like.
Absolutely, there's no
waiting for the
authority that it
citation.
does.
So you're here then essentially, Mr. Sweeney, saying, take your word for it. Responsible citizen does not include the ability to know how to use the firearm. It simply refers to age and mental state.
No, a responsible citizen could buy 900 firearms tomorrow, never use them, put them in their closet, use them as a display case, and never harm a single soul with them. They are still a responsible citizen. And the responsibility is a personal responsibility. I will go off the rails if I finish that thought. But it's a personal responsibility. I'm responsible for every freaking round that comes out of this. I'm responsible for that every day I carry it. Every day I carry it, it doesn't act or react or interact with another person. It's only on me. When I drive a car on the road, that's different. I am interacting with many, many vehicles just on my way to work. Feet from other vehicles doing anywhere from 55 to 70 miles an hour. It's a little bit different. When I carry a firearm, that gun is never interacting with anybody but me. And it is a personal responsibility for me to purchase said firearm and then go get training or train myself, because that happens a lot these days, in the use of said firearm. This is what happens when you end up with judges who are completely statist. They believe in state power. They believe the government should have the power over every part of your life. And that constitution, that state constitution, because this never should have gone any further than the state court. It should have been shot down in state court, held in state court, and the state of Maryland should have been told pound sand by judges. And in a couple of cases it was. That's the reason it worked its way up to the Fourth Circuit in the first place. But we've gotten so far away from just a standard personal responsibility. It's mind-boggling to me that these people believe that the state should have that much power.
There's no
Because I say
Supreme,
so.
there's
Isn't
no
that where
Supreme
you're
Court
leading
case.
us?
Yeah, there's no Supreme Court case that says it does. There's no Supreme Court case that says to exercise your right under the Second Amendment, you have to establish you're a member of the people. And to do that, you have to get training. That certainly wasn't the case at the time of the founding. At the time of the founding, you could acquire a handgun.
Yes, Martin.
You could acquire a musket, a weapon of war.
But doesn't the case today come down to what is the nature of the delay being imposed? And at what point does the delay become unconstitutional? And I don't think you've really refined that for us.
So-
At one point, you suggested that maybe if you could do it in a day or an hour, that was fine. But the 30-day, or as you referred to it, 6-week process was too much. Leave us with your definition, if you would, of when does a temporary delay become per se unconstitutional so as to render this law facially invalid under the Second Amendment.
So for purposes of rendering this law invalid, anything more than the 7-day wait required by 77R, which we're not challenging. And let me say that with respect.
Now, you got to catch this. He's not challenging the 77R portion of this. What he's challenging is the rest of the requirements. And it drives me nuts, but in these courts, you have to argue things in steps. So he's trying to stay away from the 7-day period so that can be attacked later. It's kind of like arguing about semi-auto bans right now, and then we can go after machine guns after we get all the semi-auto bans shot down, to put it in a really big nutshell. So hang with him here, because I'm kind of catching where he's going.
So
7 days is okay then?
I'm saying that it's okay for your ruling in this case because we're not challenging it.
Okay, so you're saying that you would have no problem with an opinion of this court that said a 7-day delay is fine? Is that what
This
you're
court
saying?
doesn't need to reach that, and I would have a problem with that. But you don't have to reach
Well,
that in
but-
this
but-
case.
Right, but we need you to tell us, when does delay become per se unconstitutional?
Spot on, Barton.
When it's more than necessary to prove you can take the firearm and you're not a prohibited person. And we know, because instant check is done for long guns, that it can be done instantly in Maryland.
Mr. Sweeney, can I ask a question related to?
You ain't wrong,
Jeff's point
Jess.
About footnote 9. Footnote 9 does refer to firearm safety courses, as at least suggests that that's part of the analysis in deciding who is a law-abiding, responsible citizen. But my
That
question
shoe
is broader.
fits.
So getting back to the final objective in this case, someone's going to have to write an opinion in this case that accounts for Bruin and accounts for that footnote. So what do you say we should do with footnote 9 in our opinion?
And I'm going to
Well,
do a
first of
show
all,
about
footnote
footnote
9 makes
9.
it
I'm
very
not going to go
clear
into it
that
tonight.
even a shell issue carry regime may be challenged when the wait times are abusive and thereby deny the right to carry in public. So that's the first thing I say about that.
Well, that sounds like a very kind of means balancing test that apparently is verboten these days, at least. by
The
some
second
folks.
thing I would say is, while they mention training, they don't mention training as part of the first step of the Bruin test to prove that you are a member of the people by demonstrating you are responsible. And frankly, there's nothing in how people has been defined that indicate one's ability, proficiency in handling a firearm.
Then where do you think the Supreme Court would locate the training that are referenced in footnote 9?
Hold on. We're going to
You
read
also
that
just-
before we get
let me
out of
finish
here.
My question, it'll be short. You also just explained to us that there's no historical analog for that. So if it's not step 2 and it's not step 1, where is it?
There are historical restrictions on carrying firearms in public.
But I'm talking
The
about the
Bruin
training,
went-
I'm talking about the training requirement, and I thought you just told me that the training.
Yes, Chess.
At the founding was only. for
Which is
Bruin.
insane.
There was no individual kind of a training.
I did, but Bruin went through very carefully the very specific restrictions, well-defined restrictions on the right to carry in public, not applying to the right to acquire, to defend in the home.
Okay, so for the right to carry in public, Bruin footnote 9 does, I don't want to do.
Well,
this
yeah,
argument,
Bob, you got me
but
there,
it's
man. They are way
references
more
to
slimy.
requirements. Where do you think those come from if it's not step 1? Because you already told us there's no historical analog.
In Bruin, they went through the laws that had restricted carrying deadly weapons to terrorize.
We'd love having you on,
purposes.
AR, anytime, man.
They
You are
went
welcome.
through surety laws, financial
And
incentives.
you got a
to
wrench,
carry
so post your
responsibly.
channel all the
Now,
time.
maybe that could be a analog from the history once you get to step 2 to justify training. I'm not here to argue that. But they also talked about eliminating one kind of carry, and as long as they allowed another. They distinguished carry from acquisition for possession in the home. And that's completely different.
Well, how do you address, and if you're talking about the footnote actually places it under step 1. It says, it appears that these shall issue regimes
got
which
the
often
footnote up
require
right
applicants to undergo background checks or pass firearms safety course are designed to ensure only that those bearing firearms in the jurisdiction are in fact, quote, law-abiding responsible citizens. Isn't that the step 1?
Dude, you're going to make me do it. Okay. For the love of Christ. I wasn't gonna, but we're gonna. Let me share this tab instead. So this is footnote 9. I'm not going to go through everything in footnote 9. It's not very long, but there's a lot of information in it. Talking about shall issue, may issue, all that. But the very last part of footnote 9, because it said it wasn't against shall issue and all that. It says, that said, because any permitting scheme can be put towards abusive ends, we do not rule out constitutional challenges to shall issue regimes where, for example, lengthy wait times in processing licenses, applications, or exorbitant fees deny ordinary citizens their right to public care. That's the last part of footnote 9. So these judges will hang to a lot of other stuff in footnote 9, but they will not actually go through the whole footnote.
Your Honor and I have disagreed on that.
No, I'm reading it. I'm asking
I
you
know
about
what
the
it
footnote.
says.
I'm not asking you to disagree. I said, what does
I
it mean?
disagree that that's addressing step 1 in that footnote.
It puts it in quotes, law-abiding, responsible citizens.
Yeah, I see that.
And it cites Heller.
I see that too.
All right, thank you, Mr. Sweeney.
Yeah, you got
Thank you,
me.
Your Honor. Thank you all for your patience with me today, and thank you for hearing the citizens of Maryland.
Yes, sir.
All right, so that's
Thank
the
you
end of
both for
this
your arguments. We'll come down
entire
and agree counsel, and we'll report
nightmare.
them. We'll move on to the rest of its docket for today. Take a brief recess after this.
Okay.
This honorable court will take a brief recess.
All right, that's the end of that entire nightmare for the day. Okay, just sent this, told to watch. I watched and effed up. Shall watch later. All right, dude, I'll have to come back and find that, Chess. Matter of fact, let me flip over to the other part of the chat and I'll open that up and I'll watch that after we get done with this, because I am going to get out of here in just a sec. There we go. Now I got it. This Elon Musk update. Oh, Dan Bongino. Hell yeah. And Dan Bongino's he's a hell of a dude, man. He's on point for sure. And yeah, you're right. It kills me with these courts. Well, all rise for the honorable justices and this honorable court. I'm sorry, if you haven't proven you have honor, you're not honorable. That should be a kind of a prerequisite for being called honorable. It's like watching Congress and they talk in hearings. Well, the honorable gentleman. Well, no, that gentleman's not honorable. But they got to go for the rules of decorum and all that. Good night, AR. And I'm fixing to get out of here. I'm fixing to shut this one down. So anyway, that was Maryland shall issue, and I guess they're going to force me. I'm going to have to go do a kind of deeper dig into footnote 9, since these people are pulling this up constantly, and they kind of forget the very last apparent, couple of sentences or sentence or so of footnote 9. They don't want to pay attention to that. They want to pick and choose very small segments of it, because what I just breezed through before I even posted that basically proves that the Maryland shall issue is complete horseshit and is not within the Bruin framework, which most of us should realize right now that permitting schemes implicate the Second Amendment, the right to keep and bear. And if there aren't any historical analogs, well, then the law is unconstitutional. That's Bruin in a nutshell, Heller in a nutshell. And boy, buddy, do they ever pervert the meaning of words? It's like blue's now green and green's now red and all that. Kind of like most of these cases should be handled in the state courts based on the state constitution and should never make it up to federal courts, because federal courts are only supposed to govern federal matters. And that's all been so perverted now. We kind of gotta skate in the ring that you're in. So I see a lot of it now. But as far as I know, there is no state that gives their state government the power to regulate the arms that their citizens own. There are a handful of states, 2, 3, that say something to the effect of how a gun is carried is subject to police powers, but none of their state constitutions say that the state has the right to regulate arms that the citizens own. Not a single one. California and a couple other states don't even mention arms, which for anybody who's rational means if that power is not explicitly given to the government, then that power belongs with the people. And the people decide how they want to manage such things, not the government. And it doesn't mean that the majority of the people get to do it. It means that the people themselves get to do it. So if I live in a state, California, doesn't mention anything about firearms ownership in the Constitution, it doesn't matter whether 98% of people in that state decide they vote for a ban on some gun. They don't have that power. The state doesn't have that power. So guess what? Those 98% of people get to go fuck themselves. Sorry, that's just the way it works. If the founders, if the people that were agreeing to the Constitution, the federal Constitution, agreeing to become states, if they agreed with any sorts of controls on arms, these people were decently intelligent. They would have written that out. I didn't realize I was so far behind. I'm always behind. But anyway, let me get out of here, guys, because if not, I could literally stay here and we could shoot the shit about this all night long. So that was Maryland shall issue. Another case, more than likely, that is not going to go well for gun owners. The Fourth Circuit, especially listening to arguments from yesterday, you've probably got about 2 judges on that 15-gun panel that are decent on firearms ownership and constitutional rights. The rest, no. I need to find, and AR brought it up, I need to find the actual, and I can go look, I think it should be on the Fourth Circuit site, where I can go find the text of this entire oral argument, where I can see what judge said what. And even Mark Smith in one of his videos today, he didn't want to commit to what judge said this or that in yesterday's hearing because, again, he didn't have the text. So I need to find that where this judge said this thing and this judge said this thing that was dumb as fuck. I'll add in my own wording on some of that and maybe do something then. But footnote 9, since I kept mentioning it tonight, I'll try to do a rundown on that. And guys, I am not the constitutional scholar extraordinaire. I never claimed to be. I'm just a simple person that believes words had meaning, and those words, when you agree to something, have the meaning that they had when you agreed to them. So as bastardized as the English language is, where words kind of have different meanings at different times, like cool and bad and all these things we use a lot, the legal text of the language is what should matter. That's also the reason you see these people who are anti-gun and anti-one right or another that play with the meanings of words so much. And I really wish we could wait more. And I say we because all you guys are in this. I really wish we could wake more people up to that. That would solve so many issues with society right now if people would just wake up to, hey, these words meant one thing when they are agreed to. They should mean that same thing in perpetuity. My insurance company doesn't get to change the meaning of words just because it's been 5 years since I've signed on a contract. It's the same thing, even if that contract's 250 years old. So that's looks like one must order the transcript of the Fourth Circuit. I don't think I got to order the transcript. I think in the next couple days, they'll actually post the transcript. And most of these courts that I've seen, I should be able to go in and find the actual text of the oral arguments. A couple of days. It normally takes them a little while to get everything transcribed. And then I should be able to find the text of it. And when we find that, we'll get into that again. The only thing I've seen so far that I have to order was some stuff coming out of state courts, which is, oh shit, where's my form? Here it is. So when Gators Guns went into state court the other day, I've got the form and I'm going to try to order the video or the transcribed whatever of Gators Guns going into the court in Washington State, because I want to go through that, and that's if I get to it. It's kind of on a side burner, but yeah, then I'd have to spend a little change to actually order the video or the transcript, and that's not out of the question. What's up, Bernie, my friend? What's happening? So anyway, I'm going to get out here tonight, guys. I'm going to go snag me something to eat, grab a shower, get ready for the day tomorrow. I love all you guys. You guys be cool. Take them easy. Thanks for hanging out. As always, keep that thing on you at all times, because let's face it, our government is not here to defend us. And in most cases, they really want us dead. So anyway, I'm getting out of here. Bernie, Chris, Barton, AR. Damn, I can't name everybody in the chat. And I hate to try to do it because you guys, Bob, Run Gun. I know I'm going to miss everybody. Krabby Turtle was in here. Chessboard, my brother. Can't remember whether Tread made it tonight. M. Gabriel was in here. Barton, Gabriel. Man, I can't make everybody. You guys are so cool. I can't even keep up. But anyway, we'll see you guys on the next one. You guys follow Dark. Dark should be on later on tonight. Tactical Turkey should have been going by now already. Follow the perps. And who knows, I might see you in the chat later on tonight. Anyway, I love all you guys. Be cool, perps. I am out. Later.